So before we pick back up where we left off, I just want to go back. Why don't you guys remind me in the chat real quick? Private chat, let's not remind everybody, but just remind me. And you can answer this pretty simply. What duties do I owe my client? What duties, how do we remember what duties I owe my client? Yep, looks like we're good. My client gets old car. So we can remember the duties that my client gets by remembering old car. So we talked about obedience, we talked about loyalty, we talked about disclosure, we talked about confidentiality, we talked about accounting, and we talked about reasonable skill, care, and diligence. And then we said, okay, well, if you're not my client, then you're my customer. So I have duties and responsibilities to my customer too. What do I owe my customer? Honesty, fairness, and the disclosure of material facts. So my client gets old car, my customer gets honesty, fairness, and the disclosure of material facts. How do you become my client? You enter into an agency agreement with my firm. We're going to get into agency agreements in Unit 8 before we leave today. Good morning. Before we leave today, we'll talk about what next week is going to look like. So if you're looking ahead, you know what to look at. I want to make sure before we get back into where we were, I want to make sure, I don't know that I specifically said it. I don't remember. If I didn't, it doesn't hurt. If I did, it doesn't hurt to hear it twice, right? With my client, I owe all of my clients old car. Price point does not matter. So the individual that signs an agency agreement with my firm that wants to purchase a $5,000 lot gets old car. The seller that enters into a listing agreement with my firm that's selling the $1 million home gets old car. Everybody with me? Price point doesn't matter. How do you get old car? You enter into an agency agreement with my firm. Everybody good with that? You make more with the $1 million house than you do on the $5,000 lot? Of course. I also want to make sure that we're all good. Real estate, it's not about houses. Real estate is about people. It's a people industry. Remember, the real estate's main purpose is to protect the public. And the public, the general public, doesn't know, various things. They may or may not know. They may not even have access to the forms. They may not know how to find a good asking price or a good price to offer. They may not know to get a home inspection. That's why they're hiring us. We are supposed to be the experts. But guys, we got to take care of the people. And let me tell you something. If you're coming into this industry driven by dollar signs, you may not be successful. If you come into this industry driven by the desire to help people, trust me, the dollar signs will follow. Okay. You take care of this client. You do a really good job with this client, and they tell their family and friends, and they tell their family and friends, and so on and so on. And that's how you grow in this industry. 30 years from now, you're not going to be prospecting. 30 years from now, you don't have to do open houses. 30 years from now, your business comes from referrals from past clients. So you treat these people good, and they tell their family and friends, my gosh, my realtor was awesome. You should call her or him. What happens when you treat them bad? They go online. That's what they do. They go online and they tell their family and friends, don't call this person. So it's a people industry. I'm telling you. You're fine. I'm telling you, you guys, it is a people industry, and I'm a firm believer in taking care of the people, and the money will follow. I'm also a firm believer in education and training ongoing. I've 21 years this year I'm going to be in the industry. I don't know everything, but I've met over my years, I've met a lot of top producers. And in sitting back and observing their habits, observing top producers, I always see two traits in top producers. Top producers are always learning. They're always sitting in a classroom. What's the latest technology? What do the current forms say? What do the rules say? They're always learning something. The other trait that I always notice with top producers is they're constantly feeding their pipeline. They're constantly trying to get business. Even if you have, 9 things under contract, if you stop prospecting, those 9 things close, and then you're starting all over again. There's a misconception in this industry that it's feast or famine. And it is a misconception, because if you feed that pipeline, constantly feed that pipeline, you're going to have a steady stream. You're going to have always things going in, things coming out. So training and education, and never stop prospecting. Anybody is a possible client or customer. There's a lot of agents in the market right now. It's very competitive to be an agent right now. I've heard recently that the average person knows 5 real estate agents. So even with your family and friends, even with the people you know, you're competing with 4 other people. What do they say? You can't walk outside and throw a rock and not hit an agent. So we have to bring our A game every time. We're going to talk in Unit 8 about our listing appointments. A lot of listing appointments are competitive now, which means sellers are talking to 2 or 3 agents and deciding which one they want to hire. You may or may not know if you're at a competitive listing appointment. So you got to bring your A game every single time. Same thing with buyers. Buyers are starting to interview agents now. So you got to be on top of your game. You got to take care of the people. And I think that's a lot of what Old Car reminds us. That's my obedience. That's my loyalty. That's my reasonable skill, care, and diligence. I promise you guys, you take care of the people, the money will follow. Do not come into this led by dollar signs. Any comments on that? Questions? And thank you guys for telling me that you're here. If you didn't, tell me you're here. Okay. So where we left off the other day, we had just started our conversation about material facts, and we had gotten as far as defining material facts. Remember, the definition of a material fact is very broad. Any information that a reasonable person would find relevant. Well, first off, define reasonable person, and second off, define relevant. It's tough. So what did the Real Estate Commission do? They tried to make it a little easier for us, and they narrowed it down to specifics. So we talked about things that are specifically considered material facts. And one thing that we didn't want to mention, that again, I just want to make sure that we touch on, I can't disclose what I don't know. There are things out there called latent defects. Latent defects. And just in case my accent's not coming through. Latent defects. Latent defects are those that aren't easily detectable. Maybe I can't see them. Maybe the home inspector can't see them. Maybe the buyer doesn't find them until after they purchase the home. If there's a problem behind this wall, if you were here and you look into this wall, I see no markings on it. I see no mold. I don't smell anything. This wall looks fine. I can't tell you that there's anything going on behind the wall. I can't tell you that there's mold behind the wall or mildew, right? The only way I could tell you is if I tear the wall down. If there is mildew, which I hope there's not, but if there is mildew behind this wall, that would be a latent defect. And it might be something that comes out later after closing. My duty is to discover what I can, always look for those red flags. Anytime you have a little red flag go up, it should prompt you to ask questions, prompt you to investigate, to learn more. Always pay attention to your little red flags and discover what you can. We have a duty to discover and disclose. But I can't. Things that are hidden, latent, things that are not obvious. That's out of my realm. So before we move on, let's just pause right here again. This is where we ended the other day. Actually, where we ended was with our little example. So before we go on, let's see if we have any questions or comments about material facts so far. So we've defined material facts. We've talked about what they are. In just a minute, there are some things in North Carolina that are not material facts. So we'll talk about those in just a minute. But it's important that we understand what happens if we don't properly handle material facts. What are the consequences to me as the broker if I don't properly disclose the material facts? You're going to be facing some disciplinary action with the Real Estate Commission. We'll talk about disciplinary action in just a bit. So what I want to do when we talk about what happens if you don't disclose your material facts, I want to go off textbook for a second. And I want to go off textbook and I just want to define some words. Let's just go back to the basics and make sure we're good with the basic meanings of some words. A misrepresentation is communicating false information. A misrepresentation is a lie. Misrepresentation, you open your mouth and a lie falls out. And please understand, when I say open your mouth, I mean you either open your mouth and lie, or you text and lie, or you email and lie, or you lie in your advertising. You somehow get the wrong information out there. On the other hand, an omission, you've kept your mouth shut. You didn't put the information out there. You didn't email it or text it. So misrepresentation, you open your mouth and a lie falls out. An omission, you kept your mouth shut. And yep, Demaria, you're right. And I'm getting there. So we're just going back to the basics and just defining some very basic words. And we're going to do a mashup in just a second. So misrepresentation is a lie. An omission, you kept your mouth shut. A willful act is one that is done intentionally. You intentionally lied, or you intentionally kept your mouth shut. You did it with knowledge. A negligent act, then, is one that is done unintentionally. It was a mistake. It was an accident. But guys, guess what? It still happened. You may not have meant for it to, but it still happened. So now if we go back to our book and we take those 4 words that we just did a basic definition of, we're going to do a mashup. And what you see in your book on page 143 is what I call the big 4, the prohibited conducts of material facts. What happens if you don't properly handle material facts? The Real Estate Commission can find you guilty of one of these 4. Now we're going to break these down and look at these and look at some examples of each. I'm in a good mood this morning. You're going to have a test question, and it's going to give you a scenario. Answer choice A is going to be willful misrepresentation. B is negligent misrep. C is willful omission. D is negligent omission. Here's test answers right here. Don't say I never gave you guys anything. Here you go. So you're going to read this scenario, and you're going to have to figure out A, B, C, or D. My suggestion to you, you're going to have to break it down because it's going to be long, right? My suggestion to you is to first stop and ask yourself, did the broker in this scenario lie, or did the broker in this scenario keep their mouth shut? Did they lie about the material fact? Did they misrepresent the material fact? Or did they keep their mouth shut and omit the material fact? Once you determine that, then go back through and determine if it was done on purpose or on accident. So always stop and ask yourself, was it a lie, or did they keep their mouth shut? Once you determine that, then go back through the scenario and determine if it was done on purpose or on accident. How do you get good at this? Well, we got examples, several places with examples. Again, we'll look at all that in just a second. So let's break down the big four. Again, these are the big four that revolve around improperly handling material facts. So prohibited conduct revolved around material facts. So willful misrepresentation. The licensee has actual knowledge of a material fact and they deliberately misinform. They know and they lie. They know it's a lie when it's coming out of their mouth, but they do it anyway. It's a lie that's done intentionally. It's a lie that's done on purpose. The licensee has actual knowledge and they still misinform. That's a willful misrepresentation. So a seller's agent is aware that the present owners of the listed property have had serious problems with electrical wiring. The listing agent is aware. Do they know? They know. Nevertheless, the broker tells a prospective purchaser that all mechanical systems are in excellent condition. Is that a lie? They knowingly lie. This is an example of willful misrepresentation. They know and they lie. The broker is guilty of willful misrepresentation. Negligent misrepresentation. The licensee unintentionally misinforms a consumer concerning a material fact because the agent does not know, has incorrect information, or has made a mistake. Please understand, it's still a lie, but it was done unintentionally. I didn't mean to, but I still lied. Can we agree negligent acts usually aren't going to be as severe as willful acts? If you do something on purpose versus on accident, with negligent acts, the real estate commission is going to perform something called the reasonable standard test. With negligent acts, the real estate commission is going to perform the reasonable standard test. And the real estate commission is going to ask, would a reasonably prudent broker should have known or have been able to find out that information? I think willful acts are more highly punishable. Negligent isn't an out. They're going to do the reasonable standard test. Could the agent have found out? I think we taught the other day in class. Wow, buyer, that's a really good question. I'm not sure of that answer. Let me find out and get back to you. I'm not just blurting something out if I don't know the answer, right? Depending on what they're asking, maybe I can help them, maybe I can't. Depending on what they're asking, maybe I need to say, wow, that's a great question for your home inspector or for your lender or for your attorney. So the reasonable standard test. So this example for negligent misrepresentation, while viewing a property in a subdivision that the buyer is quite interested in, the buyer tells their agent they want to build a large storage building in the backyard and asks if it would be permissible. Buyer's agent calls a listing agent and is told, well, everybody else in the subdivision has a storage building, so I'm sure your buyer can too as well. Where did we go wrong? Neither agent checked the covenants, nor for some reason provide a copy of those covenants to the buyer. Guess what? Both agents are going down for negligent misrepresentation. Could either agent, did the listing agent have to answer the way that they did? Absolutely not. Remember we talked about when you see a shed in the yard, the only thing you know is that somebody put a shed there? The buyer's agent had a duty to find that information. How do they find out? Would a reasonable agent know to check the covenants, to get their buyers a copy of that covenants? I believe the real estate commission would say yes. Questions on misrepresentation? Okay. So now we have willful omission. Willful omission, the licensee has actual knowledge of a material fact, a duty to disclose that fact, but they deliberately fail to disclose. They kept their mouth shut. They know, and they kept their mouth shut. They know, and they kept their mouth shut. Willful omission. Actual knowledge is a good indicator that the agent knows. So a seller's agent is aware that the listed property has suffered extensive termite damage that is not easily detectable. Regardless of whether a prospective purchaser actually inquires about possible termite infestation or damage, the broker has a duty to disclose this material fact. Not doing so would be willful omission. This is not a case of don't ask, don't tell. Just because the buyer didn't specifically say, is there termite damage, isn't an out for me not to disclose it. I always disclose material facts. The broker's case in this situation is, well, they didn't ask. That's not an out. That's willful omission. And then the last of the big four is negligent omission. The licensees do not have actual knowledge of a material fact, but should reasonably have known. Again, negligent acts, they're going to perform the reasonable standard test. Should a prudent broker reasonably have known? So a broker is viewing a house in February to list. The house is unusually cold, but the broker does not turn on the heat pump or ask the owner about its condition. As it turns out, the heat pump is inoperable. For whatever reason, this buyer chose not to have a home inspection, and they buy without ever being informed that the heat pump does not work. The listing agent could be found guilty of negligent omission because they didn't discover. That's that duty to discover and disclose. You're sitting at a listing appointment in February and it's too cold in the living room to take your big winter coat off. A flag should go up to ask some questions. Goodness, it's cold in here. You mind if we turn the heat up? Does your heat work? We got to ask some uncomfortable questions sometimes, right? We're going to get more into that in Unit 8. But the Real Estate Commission is going to say, would a reasonable agent know to ask? The name of the test is the Reasonable Standard Test. So the big four: misrepresentation, either you lie about a material fact or you omit a material fact. You either open your mouth and a lie falls out, or you keep your mouth shut. So look with me, if you will, on page 144. There's willful misrepresentation, and you see there's some examples. I think the examples help. I think the examples help solidify this information. 144 to 145 is negligent misrepresentation with examples. 145 is willful omission with examples. And then 145 to 146 is negligent omission with examples. In just a minute, I'm going to have some even more examples for you guys. So in just a minute, I'm going to give you another source. Again, I think the examples help wrap your brains, and studying those examples and those scenarios is going to get you through that test question. Questions on the big four? That's a great question. Should you go to listing appointment as though you're the one buying the house? You would ask questions? Absolutely. First off, and we're going to talk about this in Unit 8. So let's not get too far ahead of ourselves. I'm doing as much research about the home as I possibly can before I ever get there. right? Ideally, by the time I get to the listing appointment, the only thing I don't know is what the inside of the house looks like. You guys with me? I'm searching the deed and the title and the tax records and DOT and flood, and I'm doing all that before I ever get there. Your firm will provide checklists. But then we get inside, yeah, and we got to look at everything. We're going to talk about agency disclosure. The seller knows. We're going to talk about disclosure in just a bit. A question came in about the heat pump and inspection. Inspections aren't always required. Some buyers think they're going to save money by not getting an inspection. All I can do is recommend, highly recommend they get an inspection. Sometimes lenders will require a home inspection, but for the most part, they're not required. Should this buyer have gotten a home inspection? Well, gee, I think so. The reasonable standard test is for negligent acts, negligent misrepresentation, and negligent omission. The real estate commission is going to ask, would a reasonably pertinent broker have known this information? Again, when we get into Unit 8, we're going to talk about working with sellers. We'll talk about working with buyers. We'll get you that listing appointment. Okay. So we spent some time talking about things that are material facts. So now we need to talk about things in would it be unusual for a selling agent to recommend the buyer get in his, all buyer's agents should tell their buyer to get an inspection. I would never tell my buyer, nah, don't worry about that, it's fine. All buyers need to get recommended to get home inspections. Guys, can we talk about that? Let's stay on point. We'll talk about home inspections later, okay? So if we talked about things that are material facts, let's talk about things that are not material facts in North Carolina. In North Carolina, stigmatized properties are not a material fact. I think I got a lot of questions about this last week or Tuesday, I guess. So what are stigmatized properties? Oh, the haunted house on the block. Any property branded by society as undesirable. Was it the site of a death, a murder, suicide, serious illness? Mark my words. At some point in your career, when you're showing a home to a buyer, you will be asked, did somebody die in this house? And no, you have choices on how you answer that. You don't have to answer that. You can say, that's not a material fact in North Carolina. It doesn't need to be disclosed because it's not a material fact. So you can say, North Carolina License Law and Commission rule says not a material fact, and I don't have to answer it. If you choose to answer, you must do so honestly. You may know, for example, that nobody died in the home, the recent owner. But if you're saying, no, nobody ever died in this home, you need to be able to prepare to say this owner, the owner before them, the owner before them, the owner. What is the house's history? Did anybody ever die in that house? I don't know might be your honest answer. I don't know. I'm not sure. It's not a material fact. I don't have to disclose it. If you're listing the property, I don't have to disclose it. You know, some major crimes make the news. So couldn't you go to Google, search the address, see if it comes up on a news article? Or better yet, why not send your buyer to Google? Why not have your buyer investigate, encourage? Some crimes are more publicized than others. You know, here in the Triad, every once in a while, something makes the news, right? Sometimes things make the national news. It's kind of hard to hide from things that make national headlines. Sometimes you want to disclose, sometimes it's better to disclose. Because if you don't tell them, the neighbors will. So sometimes with these highly publicized crimes, it might be better to disclose. This is a North Carolina. Other states, you have to disclose. Some others, I don't know what states you do and what states you don't. But yes, some other states you have to, but in North Carolina, it is not a material fact. I was showing property once to some guys that were coming in from Iowa. And we walked into a house and the buyer looked at me and said, did anybody ever die in this house? And I said, I honestly don't know. You have to tell me that. I said, no, sir, I don't. Well, in Iowa, they have to. Well, you're not in Iowa anymore. That's one thing we need to do is help educate the buyers that laws change from state to state. So in North Carolina, I can't disclose what I don't know. If I do choose to answer, then I must do so honestly. Have you guys ever walked? If you haven't, you will. Have you ever walked into a house or anywhere and the teeny tiny little hairs on the back of your neck stand straight up? Woo, that's some crazy energy in that house, isn't that? I'm not saying that means somebody died in there. I'm just saying that's some crazy energy in that house. Did I tell him to click this? Right. You're not in Iowa anymore, Toto. Do I have to disclose if there was a fire in the house? If I know, yes. And of course, that's going to show up on the, when they go for insurance. We're going to talk all about insurance. Unit 13, homeowners insurance. There is one exception to this rule. And the exception to the stigmatized properties, if you're ever asked, did anybody live in this home that had AIDS or HIV? Your answer is always, federal fair housing prohibits me from answering that. Federal fair housing prohibits me from answering that. Those with AIDS or HIV are protected under handicap disability status under federal fair housing. I got a whole unit dedicated to federal fair housing. We'll talk about federal fair housing in Unit 19. But what we need to know is those with AIDS or HIV are protected class. And our answer is, I don't care if you know or not. Our answer is always, federal fair housing prohibits me from answering that. Why does that matter? Some things bother people. So some people don't mind living in a house where somebody died. Some people will tell you that they don't want to. Guys, everybody's different. Another thing that's not considered a material fact in North Carolina is the presence of convicted sex offenders nearby. When it comes to this one, I'm a big fan of being the source of the source. What do I mean by that? When you have buyers with kids, they very well may ask you if they're sex offenders in the neighborhood. The best thing I can do for my buyer is to send them to the sex offender registry website. Send them to the source, let them investigate it, let them look it up. Megan's Law is a law out there. It does require convicted sex offenders to register their address. So they are required to be on the registry. Let's keep a couple things in mind with this though. First off, I don't know how often that registry updates. Sex offenders can and do move. So it's important that your buyer understands that if they go to the registry, they find that there's no sex offenders in the neighborhood today. That doesn't mean a sex offender can't move into the neighborhood tomorrow. So I would caution about making any kind of guarantee that there are no sex offenders in the neighborhood. The other thing we need to pay attention to is that the word says convicted. And unfortunately, not all sex offenders are caught yet, are they? So you may have a sex offender in the neighborhood that's not convicted. They haven't been caught yet. So I would caution you guys from saying stuff like, no, there's no sex offenders around here, because you don't know, and you don't know when one may move in tomorrow. So again, the best thing we can do is be the source of the source. And if your buyer or tenant say, is there a sex offender in this neighborhood? I have kids and I want my kids to be protected. I hear you loud and clear. The best thing we can do is send them to the registry. And bottom line, you guys, we should always know where our kids are and who they're with. So even if you move into the neighborhood, make sure you know who they are and who they're with. I had a continuing education class a couple years ago, and one of the material facts came up in CE. I'm telling you guys, a lot of the stuff we talk about in pre-licensing, you will see again in continuing education throughout your career. And material facts came up in CE. And we got to this, and the one gentleman said, yeah, I listed a property some time ago. And when he was at the listing appointment, the sellers told him, the person across the street is a sex offender. Do we have to disclose that? And he said, no, we don't have to, because it's not a material fact. He said, no, let's talk about this. They had a conversation about it. And y'all know the sellers chose to disclose that. Is that not a very honorable decision? The sellers chose to disclose because they felt that if they were buying with kids, they would want to know. But understand that was their choice. It's not a material fact. They didn't have to disclose that. Any questions or comments about things that are not material facts? So with material facts, we always have a duty to discover and disclose material facts to all parties in the transaction. I don't care who you are. If you're my client, I owe you material facts. If you're my customer, I owe you material facts. If I may say that another way, I never have a reason not to disclose material facts. Is there a list of things? There's two things: stigmatized property, sex offenders, square footage. We'll talk about that in Unit 8. That's right. You don't have to disclose it. Why? Because it is not a material fact. What do I disclose? I disclose material facts. You can choose, but you're not required to. It's also important that we understand that we can't avoid responsibility by using disclaimers. You can't make a statement in your advertising, you know. Think of an example. To protect your liability. You can't waive your duty to disclose material facts by putting a disclaimer, by giving a disclaimer. And as we've talked about, it's so important that brokers are always looking out for red flags. If you have a red flag go up, it should prompt you to investigate, to ask questions, to dig a little deeper. Would I have to disclose the property across the street is occupied by a sex offender since the seller wants that information relayed? Well, no, but I work for who? I work for my seller, and I'm the one doing the advertising. You know, that agent could have said, nope, we're not going to do it. Again, the sellers chose, and he honored their decision. You don't have to disclose material facts. Okay. So on page 147, there's some additional duties. Remember, the big four revolve around material facts. So in addition to the big four, there's some additional duties. We are going to see these again. So we're going to go through these pretty quickly now. I'll talk in just a minute about where we can find them more. I have additional duties. I can't make false promises. And that includes false promises through other agents or advertising. I can't make false promises to my client or my customer. If I make a promise, I need to follow through. So remember we talked about, I don't know, let me get back to you is a perfectly good response. If you have no intention of getting back to them, then just say, I don't know, and stop talking. By telling them you're going to get back to them, you're promising what? That you're going to investigate, you're going to learn, and you're going to get back to them. So if you have no intention of getting back to them, then don't tell them you are. I have a duty to avoid conflict of interest. Now we're going to talk about dual agency. There's disclosed dual agency and undisclosed dual agency. We'll talk about that in just a bit. So put that off to the side for a bit. Avoiding conflict of interest for my principal. Remember, you guys, OCAR loyalty says I have my client's interest above all others, including my own. Self-dealing is a conflict of interest. Anything that I'm doing for my own interest that goes against my principles is self-dealing. Another conflict of interest is representing another broker without consent. My license is currently held at a real estate firm in Winston-Salem. And let's say one day I decide to move to the beach. I may choose to hold my license in addition to Winston-Salem, also at Holden Beach. And that's okay for me to be duly affiliated as long as I have consent from both brokers. Holden Beach broker has to give me consent to have my license in Winston. Winston broker has to give me consent to have my license in Holden Beach. So I can be dual affiliated as long as I have consent of both brokers. We have additional duties, client and customer. I have to properly account for their funds held in the trust account. We're going to talk all about trust account, our license, law, and commission rule, the rules that we follow when maintaining a trust account, the rules that we follow when I have somebody else's money in my hand. Both my client and customer should expect that I act competently and that I avoid improper conduct. They really take the fun out of it, don't they? I can't lie. I can't act incompetently. I can't act improperly. I have a duty to deliver instruments to my client and customer. What's an instrument, you ask? An instrument is just any document related to this transaction. So our instruments start with our agency agreement when we first form our agency relationship. Go on, hopefully, eventually we have contract paperwork. And if everything goes right, going forward, we then finally have closing paperwork. Kind of the general rule of thumb here says if my client or principal sign a document, they deserve a copy of it. And the commission rule says I have 3 days to get them that copy. You can't wait until the end of the transaction and send them all of the transactional documents then. So your seller signs the listing agreement. You have 3 days to send an email with a PDF attachment that says, here is the listing agreement, our signed listing agreement. I look forward to working with you. And please note, my job is to deliver it. What they do with it when they receive it, not on me. They're going to throw it away. They're going to file it. My job is to deliver it. And I have to deliver all instruments within 3 days of execution, within 3 days of being signed. And again, I got to say, it doesn't take us 3 days. It's as simple as sending an email with a PDF attachment. Here you go. I don't know if we've done this yet in this class or not, but if not, this is a good reminder. I want you guys to write this down. I don't think we have. Everybody get ready to write this down. Document everything. Document everything. What do you document? Every single thing. Because guys, if you got verbal, you got nothing. How do you prove yourself? You prove yourself with your documentation. When you send this email, are you going to keep that sent email? Are you going to keep that sent email in your file? You're keeping all your emails anyway, right? But you're going to keep that sent email that shows where you sent the agency agreement, shows where you emailed the offer to purchase and contract, shows where you sent the closing paperwork. Document everything. We'll see this again when we get to license law. I'm sorry, when we get to our disciplinary act, just a second. The exception to this rule, the delivery of instruments within 3 days, the exception to this rule is when you're delivering offers to your seller. When you're delivering offers to your seller, you deliver those immediately, but in no event later than 3 days. So you get an offer. When do you call your seller? Tomorrow? No. The exception, offers to sellers, delivering offers to sellers. You deliver those immediately, but in no event later than 3 days. We'll talk more about that in our contract units, units 9 and 10. I have a duty. Disclose any commissions, referral fees, or kickbacks. Again, we'll talk more about this when we get into our commissions. Unit 8, we got rules in place about what, if any, kickbacks I'm allowed to receive. We'll get into that in Unit 21. Parties deserve to know if I'm making money off of the transaction. Bottom line, that's what it comes down to. If I stand to make any kind of bonus, parties deserve to know that. Please note on page 147, the in practice talks about errors and omissions insurance. Most of your firms, most firms, not all, but most firms will provide you with E&O insurance. This is like our medical malpractice. So as long as we didn't do anything on purpose, they're not going to cover you if you intentionally did something. Accidents happen. And if that's the case, most of us are covered under E&O, error and omission. Questions? Okay. So, gee, Julie, what's the big deal? Well, there's liabilities and consequences to breach of our duties of an agent. First and foremost, you can face disciplinary action by the North Carolina Real Estate Commission. The North Carolina Real Estate Commission regulates your license. The Real Estate Commission giveth you your license. The Real Estate Commission can taketh it away. If you violate one of their laws or rules, you could face disciplinary action. They could suspend your license for a period of time. They could revoke your license. They could slap you on the wrist. It's important that we understand that all disciplinary actions are handled on a case-by-case scenario. There is no flat across the board. This is the punishment. They review every single disciplinary action case by case. So one way that these can start, the consumer can file a complaint on you through the Real Estate Commission's website. There's a button on the homepage that says file a complaint. If the consumer files a complaint, that does not mean you're going to face disciplinary action. If the consumer files a complaint, if the commission finds that it's a violation of license law or commission rule, they will send you what's called a letter of inquiry. The letter of inquiry is your opportunity to respond with your story. The Real Estate Commission understands that there's 2, if not 3 sides to every story. So just because somebody files a complaint doesn't mean you're going to have your license suspended. Somebody files a complaint, it starts the investigation. They send you this letter of inquiry. They tell you what the complaint is, and they're going to tell you to get your documentation together. They're going to tell you they're going to want to see agency agreements. They're going to want to see the disclosure, which we'll talk about in just a bit. They're going to want to see any documentation that you have that supports that you did or did not do what you're accused of doing. Guys, you're not going to be able to call the commission and say, I didn't do it. The only way you can respond is with your written documentation. So remind me, what do we document? Everything. If you ever get a complaint filed upon you, your documentation is going to be your out. So you respond, you get the letter of inquiry, you respond, the commission reviews it. If they need more information, they'll reach out to you. If they want to investigate you further, you may get invited to Raleigh to stand in front of the 9 commissioners and state your case. If you ever have to meet with the commissioners to defend yourself, it is absolutely recommended that you take your own legal representation. If you get to that point, you have to go to Raleigh, and I think they're doing it on Zoom now. So if they have to go to Raleigh, you're absolutely welcome to take your own legal representation. The letter of inquiry, we call it the brown envelope, the dreaded brown envelope. It's not over yet. As my role as an admin over the years, I've seen several letters of inquiry. Not a one of them have had my name on it. I feel the need to say that. None of them have said Julie. Okay. So the letters of inquiry that I've seen come in, the agents have been able to respond with their documentation, and they're clear because they have the proper documentation. I remember we got a letter once and my broker in charge looked at me and she said, of all the, I hate that we got this letter of inquiry, but of all the agents in the office, I'm glad she got it because I know she keeps all her emails. I know she keeps all of her texts. I know she keeps all of her transactional documentation. How does she get out of it? Because she documented. Another one I know about was a he said, she said. Agent got accused of doing something. She responded with her text communication to the consumer that she said it. She had a date and a time stamp. I don't know why people are sometimes quick to hit that button, but sometimes they are. And I'm telling you guys, how you get out of it, how you protect yourself is you document. You respond with your documentation. All the cases that I know of, after the commission reviewed it, their next response was, thank you for your attention to this matter. This issue's been closed. Have a nice day. Question comes in. How do you ever find out if an agent has had a complaint? I don't know that you can. We're going to look in just a second, but I don't know that you can search an agent to see if they've ever had a complaint. I don't know if the commission is privy. We're going to look at something in just a minute when we get back from break. Does each firm have a legal rep as a go-to? No, but we have attorneys that we work with. So, you know, I can have, but a big firm might have, but most firms don't have their own legal representation. There is it. So I have an app. I was getting there. I have an app on my phone. It's called Text to Email. That's what mine's called. Everybody's different. Text to email. And my app allows me to convert text messages to emails. Now I have, to a PDF. Now I have a PDF document of my text communications that I can put in my transaction file with date and time stamp. And that's how my coworker responded to her complaint. Not only did she have the text, I mean, she had the actual email or the actual text, excuse me. Save all of your emails, sent and received. Saved all of your documents, save all of your texts. Mine is called Text to Email. Please don't look now, wait till break or after class. But guys, they're all different. That's just what mine is. There's a whole bunch out there. So you can go out and play Text to Email. So what do we document? Everything. Why do we document everything? Because you never know when a consumer is going to hit on a file a complaint button. They're for some reason unsatisfied after settlement. Guess where they're going? They're going to try to go to their agent first. The other thing I want to say before we go to break, and I'm going to say one more thing about this when we get back. The Real Estate Commission is a licensing regulatory body, which means they discipline your license. The Real Estate Commission will never fine you. However, the consumer can take you to court and you can be sued, but you're not going to be fined through the Real Estate Commission. They only regulate your license. Okay. So let's take 10. We come back. I'm going to say one more thing about this, and then we go on. Are we back? All right. I am going to take attendance, and then I just want to show you guys one more thing. And then we're going to keep going in unit 7. So just to kind of introduce you guys to the North Carolina Real Estate Commission's website, ncrec.gov, or, just Google North Carolina Real Estate Commission. And this is a public site, which means everybody has access to it. Remember, the commission's main purpose is to protect the public. And one way that they can protect the public is by helping to educate the public. So they have a lot of tools and resources available. This is a great resource for information. You can see the various tabs up here. For example, the publications, and there's all sorts of good stuff in here. These are those Q&A brochures that I put some of them in Learn, Test, Pass for you guys. When you're working with the public, you're going to help educate the public as well. And there's no point in recreating the wheel. Understand that the wheel has already been created. And again, this is one of the places that you can find some information. So know that it's here. If you haven't, start kind of playing around with it a little bit. Don't spend all your study time on the Real Estate Commission's website, but know that it's here as another tool or resource for you guys. And I just want to show you, we're on the home page, and we scroll down, and there's a couple things down here. First off, apply for a license. We're going to go through this process. We're going to discuss this process in a couple weeks. So do not worry about this right now. It is way too early. And know in a few weeks, we'll talk about that. But check out right here on the home page, easy for everybody to find, is the opportunity for the consumer to file a complaint against their licensee. The Real Estate Commission, probably about, 5-8 years ago, the button's always been here, the file complaint, but it was like embedded in the website, like you had to dig around to find it. And the Real Estate Commission's legal team, about 5-8 years ago, highly recommended that they make it easier for the consumer to find. So now they put it on the homepage. And the year that they put this button on the homepage, complaints went up 80%. Why? Because it was easier for consumers to get to. But guys, somebody before break in the chat mentioned Yelp. Yelp has made us all online critics, hasn't it? And the commission understands that just because somebody clicks on this button doesn't mean that their complaint is legit. That's why they investigate. If they ever send you the letter of inquiry, they've made sure it's a violation of licensed law and commission rule. So just because somebody hits this button doesn't mean you're going to get a letter of inquiry. If you do, you just respond with your documentation. I think it was 2020, 2 years ago. The Real Estate Commission sent all licensees in the state an email. We all got an email. Said, guys, we're getting a lot of complaints from consumers that their brokers are cussing them out. People were saying that their agents were cussing them out. And there were enough complaints that the commission felt the need to email all of us and say, guys, come on, let's not cuss them out. We are the professional here. Cussing somebody out is not a violation of licensed law and commission rule. But just remember, we're the professional. Do people upset us? Of course they do. But cussing them now out is not the route to go. So, and by the way, that year that the complaints went up 80%, the number of disciplinary actions did not. So a lot of times people are out here just blowing smoke because, again, they think they're an online critic. I didn't like Julie's shirt, color of Julie's shirt. And they think they can file a complaint. The commission says, well, that's not a violation of licensed law and commission rule, so we're not even going to touch it. If you have a disciplinary, somebody asked if you could search agents to see if they've had a complaint filed against them. And that, I imagine that information is privy to the commission. But what they do publish, each month they put out an e-bulletin. I get an email on the first of every month. They are diligent. The first of every month, I get an email with an e-bulletin. And they also put the e-bulletin, again, I'm still on the home page. So they also put the e-bulletin on the home page for the consumer. And, you know, it's a good opportunity. Like, here are our commissioners, you know, Happy New Year. Here are our commissioners. And here's some featured articles. It's a good opportunity for the real estate commission to get information out to all of us licensees, all of us, to get, if anything changes or any announcements or anything, they put it in the bulletin. And one thing that every single bulletin includes, if you come down to the bottom, you see where it says disciplinary action? Look what happens when I click on this. Y'all ready? Brace yourselves. There are the names, the cities, the violations, what happened, what they did to their license. It's all here. So in the month of probably November and December, these were the people that got their license disciplined. So when you get your license disciplined, what's worse than getting your license disciplined? Getting put in the bulletin. I live my life to stay out of the e-bulletin. Always stop and ask yourself, is this activity going to land me on the e-bulletin? How do you stay out of the e-bulletin? You know, license, law, and commission rule. That's the one thing that's going to keep you out of the e-bulletin. I always feel that my job is twofold. I'm here to help you guys get your license. I'm here to help you get through your state exam, my exam, and your state exam, and help you get your license. The second part, I want to keep you out of the e-bulletin once you do get your license. I don't know if I'm bragging. I'm not sure. I did have a former pre-licensing student show up in the e-bulletin one time. And I said, dude, we talked about that. Come on. So, you know, again, I don't want you guys, a lot of violations are about the trust account, mishandling of the trust account or the escrow account. That's what you see, I think, the most often. You know, it might be, you know, something for you guys just to look at. Don't spend all your study time looking at the disciplinary actions. I hope I put a little bit of fear in you. I don't want to put fear in you, but I hope I kind of woke you up and made you realize that the stuff that we're talking about, the reason we're here, we're trying to protect your license. You guys work awfully hard to get that license, and I want to protect it once you get it. So live your life. Stop and ask yourself, is this going to get me in the e-bulletin? Is that not crazy? And I tell you guys, when we get the email, every single month I open it up. Yeah, I'll look at this stuff later. You know where I go first? Boom. Because I want to know who I know. And yes, I see people that I know. And it breaks my heart because I know they know better. So don't let one bad decision. That's right, William. You got other resources. You have your broker in charge. You have tools. You have forms. Once you join some of your associations, like the North Carolina Association of Realtors, we have a legal hotline. So I can email or call an attorney. So when in doubt, find out. It's pretty simple. When in doubt, find out. Don't just act and wind up in the e-bulletin. So with that being said, let's look in your books and let's look at page. Go to the back and let's look at page 569. Appendix A is your license, law, and commission rule. How do you stay out of the bulletin? Appendix A. You can't play the game until you know the rules, right? Appendix A is the rules. So if you look on page 570, 570 is your license law, your real estate license law. Let's be honest, law is not an easy read. Have you ever sat down and tried to read law before? Can we say boring? what we're going to do is try to break this down. I'm pointing it out where it is to you, but we're going to break it down. I'll talk about that in just a second. So Appendix A, page 570 is your license law. Flip over to page 611. 611. Starts your commission rule. So it consists of two pieces, license law and commission rule. What I want you guys to start to focus on, turn with me to page 707. (707) is the license law and rule comments. 707 takes the license law, it takes the commission rule, and it simplifies it. Again, reading law and rule is not easy. I want you guys to start reading license law and rule comments on page 707. This is the very last section that we have in this class. We end with license law and commission rule. And I want you guys to start reading 707 now. Don't try to do it in one sitting. This is not an easy read. This is why I'm telling you, like 5-6 weeks out. Break it down into chunks. Do, 10 minutes, a study session or a section at a time. If you break it down into chunks, it's going to go a lot smoother. If you look at it before we get to the end of class, license law and commission rule section, it's going to be easier for you to understand. Have you guys ever heard the saying, how do you eat an elephant? Do you guys know how you eat an elephant? One bite at a time. So the comments on page 707 is your elephant. How do you read? How do you handle 707? One piece at a time, one section at a time. Flip with me, if you will. Let's look at page 710 in the comments. You see on the second column there, what's it say? Material facts. 711, willful misrepresentation with even more examples. Negligent misrepresentation with examples on 712. Are you guys seeing this? Willful omission, 712 with examples. Negligent omission, 713 with examples. Check out the bottom of 713, making false promises with examples. Those additional duties that we just talked about, 714, 715, all with examples. What does it mean to you if we talk about it in Unit 7, and we're getting ready to talk about it again at the end of the class in License Law and Commission Rule? Is this stuff important? I sure hope you're nodding your head yes right now. There's a reason it's in the book twice. There's a reason we discuss this stuff twice. So I'm telling you guys about this now. We're touching on license law and commission rule. We started in Unit 7, but we're specifically going to get to this. Most of everything you need to know is in this law and rule comment section. There are some laws and rules that you need to know that aren't in here, and trust me, we will get to it. We will cover it. The Real Estate Commission thinks you should be reading all of Appendix A. License law and commission rule and the comments. Past experience has told me that that's not going to happen. So I'm helping to simplify it for you guys. I'm helping it to make it easy for you. And I'm asking you to please, between now and the time we cover it at the end of class, to read the comments to start on page 707. So how do you stay out of the bulletin? You're looking at it. It's Appendix A. So start now. The best advice I can give you is to start now. Questions, comments, concerns? It just got real, didn't it? Okay, everybody good? All right. Let's go back into Unit 7. To me, this is the scariest slide. So liability consequences of the agent, again, disciplinary action by the real estate commission. They regulate your license. They're not going to fine you, but they can discipline your license. Again, the consumer that you injured can hire an attorney and they can sue you. They can bring a civil action. They could also bring criminal prosecution through it with an attorney. That could shake out to a misdemeanor. And we're going to talk more about this last one in just a second. I think a good example of this is going to be if the buyer sues the seller after the transaction, you know, the buyer feels that the seller didn't disclose. Remember, the seller doesn't have to, let me rephrase that. The seller doesn't have to disclose. But if the buyer feels that the seller lied, that's the one thing the seller can't do is lie. The buyer may hire an attorney and try to sue the seller after settlement. Again, we'll talk more about that in just a second. We'll probably get involved in that if that happens. And if it's found that our actions were result of the misconduct of the principal, then we might be able to avoid that civil liability. So if my actions was based on the principal's lie and I had no way of proving that, discovering that, I may be able to avoid liability. I might get myself in trouble if the real estate commission and the court determines that I could have found out. And that's that reasonable standard test. So, you know, for example, you're at the listing appointment and you're going through your checklist with the seller and you get to the kitchen and you say, do all appliances work? And the seller says, yeah, everything works fine. You know, unless I have a flag go up, I have no reason to run over there. Well, we'll see about that. Turn the oven on, turn the burners on, right? Now, if one of the burners is broke or something, that should raise up a flag for me to ask some more questions. But if I can't see anything wrong with it, then I have nothing else to go on but the seller's statement that all appliances in the kitchen work just fine. So we'll kind of see that more in just a second. Any questions, comments? It's important that we understand that our agency agreements are a contract between the seller and the firm or the buyer and the firm. And contracts typically are a two-way street, which means both parties owe duties and obligations to each other. So we've talked some about duties and obligations that I owe my client. Let's talk now about duties that the client owes me. The client owes me the duty to act in good faith. The client shouldn't do anything that hinders my ability to do my job. If they hire me to do a job, if they hire me to list and sell their home, imagine, if you will, that the seller, we enter into an agency agreement, I list their property, and then the seller declines every single showing appointment. It's hard for me to sell your house if you won't let a buyer in the front door. That's a duty that the seller owes me. Now, okay, so the seller's sick today. Maybe they tested positive for COVID. I don't want to go in your house today. So let me know when you're better, and then we'll start showings back up, right? Sometimes your seller will say, well, we have a new baby and nap time is from 1 to 3. Great. We won't have showings between 1 and 3. So I'm not saying we can't work together and allow showings. What I'm saying is, if the seller never, ever, ever allows a buyer in the front door. Okay, so I got a question. I hate to get off topic, but we keep all records for 3 years. We will cover that. Principal is at the duties that the principal is the agent. They owe me compensation. They're hiring me to do a job. Yes. And upon completion of my job, don't I deserve to get paid? Everybody shake your head. Yes. If you hire me to sell your house, I sell your house. Don't I deserve to get paid? You hire me to help you find a house. I find you a house, get you closed. Don't I deserve to get paid? Our agency agreements are employment contracts. And employment contracts have to discuss compensation. So remember the other day, we said, typically, the seller pays the commission to the listing firm. The listing firm pays the commission to the selling firm, to the firm that brings the buyer. The listing agreement spells out the compensation. The listing agreement says, I agree to pay you X amount. And I even go as far as to tell the seller, of X amount, I'm going to give half of it or 45% of it, whatever, to whomever brings the buyer. So it lays out the compensation. We'll talk about that when we get to agency agreements. Our buyer's agency agreement has to discuss commission too, because what if the seller isn't paying? What if, for example, the seller is for sale by owner? Does the for sale by owner have to pay me commission? No, they have no agreement. They have no agency agreement. They're going it alone. So my buyer's interested in a for sale by owner. I call the for sale by owner and I say, hey, I got an interested buyer. Can we come by this afternoon? Seller says, of course. And I say, by the way, are you willing to pay me? And the seller says, no. Does that mean I'm not going to get paid? No. My agency agreement says I will always ask the seller first. But if the seller can't or won't pay me, the buyer has to pay me. There's only two parties to the transaction. There's only two people that can pay me. I'll go to the seller first. If they can't do it, the buyer's up. So they owe me, both. Anybody owes me the duty to act in good faith. And they owe me money when I've done the job that they hire me to do. We're getting into compensation a little bit in just a minute and then more in Unit 8. The principal also has duties to third parties. Bottom line, the principal can't lie. Again, if it's determined after closing that the seller lied to the buyer may be able to sue the seller. What are we going to do if after settlement, your buyer calls you and says, I'm so mad they lied. What should I do? What do you think we're going to tell our buyer to do? Maybe call an attorney, CYA. I can't offer legal advice. So if your client after the transaction thinks they want to sue the other side, send them to an attorney. Liabilities and consequences of breach of duty by the principal. Again, the principal could be subject to civil lawsuit, criminal prosecution. And this is what I was saying earlier. They may be held responsible for my misconduct. So if my actions are a result of their lie, for example, they may be responsible for my misconduct as well. Only a judge can determine that. Let's say, here's a good example. Let's say the seller knows that the basement floods every time we get a heavy rain. So the spring, the basement floods. And I get a call to go list this home. And I'm on my listing appointment and we haven't seen rain in months, which means the basement hasn't flooded in months, right? And I asked the seller, do you have any problems when it rains, any drainage issues? And they say, nah. I have nothing to go on but rely on what they tell me, right? If it hasn't rained, I can't see that the basement's flooded. It's dry, so it's not like I can smell it. You guys with me? That would be the kind of thing. Now the buyer buys, they find out after settlement that the basement floods. They call me and say, my basement's flooded. And I say, oh my gosh, that's horrible. Call your attorney. And then just real quick at the bottom of page 148, talks about the Unfair Deceptive Trade Practices Act. Again, just be careful in your advertising. We can't lie. And the Unfair Deceptive Trade Practices Act could get involved as well. Sellers could be liable if it's found that they lie. Puffing is not lying. Puffing is an exaggerated opinion. It's close. It's close, but it's not a lie. Bluffing, puffing, there you go. Okay. Top of page 149, classification of agency relationship. Dog ear this page, circle that section, highlight that section, put a big star next to it. Classification of agency relationships is a problem topic all day long. So make yourself some notes to spend time with this section. In classification of agency relationships, we have 3 classes of agency relationships. And the first class is universal agent. If you're acting as a universal agent on somebody, you are acting with full power. You may have power of attorney over somebody. In real estate transactions, in real estate, the universal agent is the unicorn. Think this through. Your agency relationship is with whom? It's with the firm. Would anybody in their right mind give full power of attorney to, for example, Alan Tate? Would you let Alan Tate handle your affairs and make decisions for you? Give them full power of attorney. Universal agent in a real estate transaction is really, really rare because you have full power. You have all the power. The general agent has some power. The general agent has limited decision-making abilities. The general agent may bind their principal on certain matters of importance. Some examples of who the general agent is: the relationship between the owner and the property manager. The property manager, and we're going to talk more about property management in Unit 12. The property manager is hired to manage the owner's property. They're hired to manage the property on behalf of the owner. And they have some decision-making ability. There are things that they can decide on their own. What are those decision-making ability? What is their authority? It's all spelled out in their property management agreement. The two have to agree to what that authority is at the beginning of their relationship. Think about it. If you hire somebody to manage your property and they got to call you over every little thing, at some point you're going to start wondering why you're paying this person, right? If they can't make decisions on their own, then why the heck are you paying them? So that relationship is a general agent. It has some decision-making authority, some ability to bind. Yeah, William? Where you at? You might be on mute. I don't hear anything. Oh, gotcha. Okay. Another example of a general agent is your relationship with your firm. Once you affiliate with your firm, and we're going to talk about being an independent contractor and affiliation with your firm. We'll talk all about that. It's either at the end of Unit 7 or Unit 8. The relationship that you have with your firm is one of a general agent. Remember the agency agreement. The agency agreement is with the client and the firm, right? The firm allows me to work with their client. How do they allow me to work with their client? Because I'm a general agent. I have some decision-making ability. Can I negotiate my commission, for example? Well, that's up to firm's policy. All firms are different. They all have different policies. We'll talk more about the firm. But the relationship that I have with my firm is one of a general agent. And I know what I'm allowed to do. I know the decisions I'm allowed to make. It's all part of the firm's policy. So if the universal agent has full power, the general agent has some power. How much power do you think the special agent has? 0. Special agent has 0 power. If you're going into sales, you're a special agent. Residential sales, commercial sales, the relationship with the buyer and the seller. I cannot speak for my buyers or sellers. I only speak on their behalf. I cannot make decisions for my buyers or sellers. For example, you guys remember, what offers do I present to my sellers? What offers do I present to my sellers? Yeah. No, what offers do I present to my sellers? And I present all of them. Why? Because I don't have the ability, I don't have the authority to accept or reject an offer on their behalf. I cannot make that decision for them because I'm a special agent. So sales, residential sales, commercial sales. If you're going into sales, you're special. I mean, we're all special. But if you're going into sales, you're really special. Universal has full, general has some, special has none. Questions? Bottom page 149 over 150, we define some more words. Let's see, I got a question come in. You will be special if you're going into sales. I don't know if you're going into sales. If you're going into property management, you'll be general. So will you mostly be special? If you're doing sales, you will be special. Okay. Defining some more words. Brokerage. Brokerage is just the business of bringing buyers and sellers together in a marketplace. We help connect buyers and sellers. We brokerage the deal by bringing the two together. Seller's got to sell 123 Main Street. Buyer wants to buy 123 Main Street. I've assisted in brokeraging the deal. The broker is the individual person. We tend to use broker and agent interchangeably. North Carolina is a broker state, which means once you get your license, we're all brokers. There's different classifications of a broker. We'll talk more about those. But we're all brokers, just different classifications. In a sales transaction, commission is typically what we get paid. If you're property management, for example, you might get a flat fee every month. Typically in real estate, in residential sales, commercial sales, if you're getting paid a commission, you get paid when it closes. So at the end of the transactions when we get paid. What happens if it never closes? You probably don't get paid. I wish I could stand here and tell you guys that they all close. I'm not going to lie to you. You get paid when it closes. You get paid commission. When we get into Unit 8, we're going to talk more about commission. Unit 8, we're going to do the math to teach you how to figure out your commission. So that's fun math. That's math that we generally like. And then a cooperating broker. These are all brokers within your MLS that are in different firms. So you're all a member of the same MLS, but you're affiliated with different firms. And when you're working with an agent with a different firm, we're cooperating together. Two firms are coming together to cooperate to brokerage this transaction. Compare a cooperating broker and a cooperating transaction to an in-house transaction and an in-house broker. In-house means we're in the same firm. So cooperating brokers, same MLS, just with a different firm, but we still have a duty to get our clients to the end of the transaction. We work all the time with agents with other firms. And in North Carolina, the real estate license requirement is 3 activities. There are 3 activities required to have a license. The transfer of real property for others for compensation. If you're involved in the transfer of real property for others for compensation, a license is required. And when we refer to the transfer of real property, we can always remember LL Beans. The activities involved in transferring property are list, lease, buy, exchange, auction, negotiate, or sell. For others, for compensation. Imagine, if you will, a funnel. All 3 activities are required to have a license requirement. Let's say, for example, for sale by owner. For sale by owner is not doing it for others. Who are they doing it for? They're doing it for themselves. So does a for sale by owner need a license? No, because to need a license, you need all 3 activities. Compensation, we tend to think of money, of course, but compensation is just anything of value. So if you're working for free, you don't need a license. Please don't work for free. Call me before you think you want to work for free. But if you decide you want to work for free, 0 compensation, you don't need a license. Anything of value. Let's say, for example, you think you want to manage property that your parents own. And in exchange for you managing that property, they offer you free rent. Is free rent some form of compensation? Sure. So if you're going to do that for your parents, you would need a license. Everybody good with that? All 3 activities are required to have a license. If any one is missing, then you don't have to have a license. Question? Maybe an accidental unmute. What happens if you do so without a license? Well, you're not going to get a license. You could be sued. You could be fined. You're going to wind up on a list from the Real Estate Commission. So if you ever do try to get a license, they're going to be like, this person already broke the rules before they got here. What do we mean by leases? Tenant landlord relationship, a lease. Unit 11 is dedicated to the tenant landlord relationship. They sign a lease. Okay. Talking about So only a licensed agent can countersign the lease if they're doing it for others, right? If you're leasing your own property that you own, then you don't need a license because you're doing it for yourself. You're not doing it for others. You got to own the property though. That's the trick there. Okay. Creation of agency relationships, several different ways that we can create agency relationships. The first way is what Unit 8 is set aside for. The first way we create agency relationships is our contracts between the firm and the client. So in Unit 8, we're going to get to our listing agreements. We're going to get to our buyer agency contracts. We're going to look at property management contracts in Unit 12. Tenants may have representation as well. Tenant representation is more common in commercial transactions. So if anybody's getting into commercial, the tenant may want to be represented. Again, we'll see this again in Unit 8. Agency agreements are just one way to create agency relationships. As we mentioned, you will affiliate with your firm. You guys are going in as independent contractors for the most part. We'll talk about that. I can't remember if it's the end of Unit 7 or Unit 8. But you will have a brokerage employment contract, an independent contractor agreement. You'll have some kind of agreement with your firm. The firm's not hiring you. You're affiliating with them. All firms are different. All contractor agreements are different. Talking more about that in Unit 8 or in a bit, 7 or 8. And then there's a cooperation agreement. The cooperation agreement is the listing firm's commitment, is the listing firm's agreement to pay the firm that brings the buyer. And when I look in MLS, I can see how much commission they're offering to pay me. So my buyer says, ooh, I want to go see 123 Main Street this afternoon. I pull up MLS and I see how much the listing firm is going to pay me when I sell 123 Main Street to my buyer. That's the cooperation agreement. It's an agreement between brokers from different firms to compensate each other. Another way agency relationships are created is implied agency. Implied agency is conducts of the party. You just start acting like somebody's agent without entering into an agreement. Yeah, that's not allowed. We enter into an agency agreement, we have a discussion. We have an express agreement. We're looking at that next. So implied agency, just starting to act like somebody's agent, make them think you are their agent based on your actions. It's implied agency, and that is not allowed. Compare implied agency to an express agreement, implied agreement to an express agreement. An express agreement is clearly laid out. The terms are stated. I'm going to do this, this, and this. You're going to do this, this, and this. And at the end of the transaction, you're going to pay me. Express agreements in general can be oral or they can be in writing. Anything we do in real estate eventually has to be in writing. Because if you got oral, you got nothing. Would you rely on putting food on your table for your family from a handshake from a seller? I promise, if you sell my house, I pay you. I'll pay you. Is that good enough for you? Absolutely not. How do we hold the seller to that? We put that thing in writing. So express agreements can be in writing or written. In real estate, they are writing. Again, compare that to an implied agreement created by the actions of the agents. Again, implied agreements in real estate are not allowed. Everything we do is express. The terms are clearly stated. And then apparent authority. Apparent authority is when the principal expects me to go above and beyond what is allowed. The principal knows, for example, My seller knows that I can't accept an offer on their behalf. They know that I have to bring them all offers. We have to talk about it. I cannot accept or reject on their behalf without having a discussion with them first. They know this because we've talked to them about this. Let's say your seller's gone out of town this weekend and they call you and say, I know you can't accept an offer on my behalf, but I'm going out of town. If an offer comes in, go ahead and sign for me. That's apparent authority. Yeah, we're not allowed to do that either. I'm sorry you're going out of town. Please check in with me if you can. If I get an offer, I have to present it to you and I cannot respond on your behalf. Questions? Okay. Let's take 10. We keep going. All right. Back from break. Okay. Questions? Any questions? So let's start talking a little bit about your compensation. Again, the big commission conversation is going to happen in Unit 8, but we do start talking about it here in 7. And what we need to understand in 7 is who we owe our loyalty to. I owe my loyalty to the one that hires me. Who hires me? The one that enters into an agency agreement with me. It may or may not be the person that's paying me. The person paying me is not who I owe my loyalty to. It is the one that enters into the agency agreement with me. Remember what we've been saying. Typically, if it's in MLS, the seller hires the listing firm, the seller pays the listing firm. The listing firm shares their commission with whomever's bringing the buyer. So if I'm the buyer's agent, that means the buyer hired me, yes, but the seller's paying me through the listing firm. Seller pays the listing firm shares their commission with me. My loyalty is to the buyer because they're the ones that hired me. And a big reason why we put our agency agreements in writing is to protect our commission. Again, I would not try to feed my family on a handshake from a seller. Sure, I'll pay you. Where's that going to get me? It's going to get me ramen noodles and saltine crackers, right? I like steak. Bless you. So agency agreements, a big reason we put those in writing. And again, we'll get to this in Unit 8. Big reason we put this in writing is to protect your commission. Agency agreements are not for forever. They must end. And to talk about different ways that they can end, let's all look on page 152. There's bullet points on 152. I didn't really see the need to redo it. Everything you need to know is right here on 152. There are different ways that an agency agreement can end. First up is completion or fulfillment of the purpose. Once I've done the job you've hired me to do, we're done. If you hire me to list and sell your home, once that deed conveys, once the buyer gets the deed, we're done. I've done my job. I sold your home. If you hire me to help you locate and purchase a home, once you get that new deed and those new keys, my job's done. I have completed the purpose. I have fulfilled the purpose. As we'll learn in Unit 8, all agency agreements have a definite end date. All agency agreements have an expiration date, and when they're over, they are over. Can we agree to extend it? Of course we can. But if our agency agreement's expiration date is dated January 20th, I figure out what today was. If our expiration date is January 20th, that means at 11:59 p.m. tonight, we're done. I don't know you anything. When it's over, it's over. Agency agreements can end by mutual agreement. The agency agreement is between the client and the who? The firm. Can you fire a client? Can the individual broker fire the client? No, it's not your client to fire. Whose client is it? It's the firm's client. The firm and the principal may decide to mutually end the agency agreement. Breach of either party may end the agency agreement. Operation of law. If you have a listing agreement and the seller loses the property through bankruptcy, it's no longer the seller's to sell, is it? The bank has taken the property, and now the bank is the owner. So that would terminate the agency agreement. Destruction or condemnation of the property. If you have a house listed for sale and the house burns down, you don't have a product to sell anymore, that could end the agency agreement. And then lastly is death or incapacity of either party, remembering that the relationship is between the client and the firm. So if the individual broker passes away, the show goes on. In order for the firm to die, the firm would have to shut their doors. The firm would have to dissolve. So we've been saying when it's over, it's over. Typically, it's over when it's over. Some exceptions, some things I may continued obligations. If I have not fulfilled a promise or an obligation and our agency agreement ends, I still need to keep my promises. Remember, I can't break my promises, can't make false promises. So if our agency agreement is over, maybe an example of this, I told my buyer, after I told my buyer that I provide them, I don't know, with a list of my preferred vendors, my preferred handyman, repairman, painters, etc. And we go to closing, our agency agreement's over, but I still promised that I would send them that list. So even though their agency agreement's over, I still need to get them that list. Agency duties continue if the agency agreement ends while we're under contract. I'm not going to abandon them when we're under contract. Best practice is to get the agency agreement extended through closing. So you have that in writing. Extend your agency agreement, but if you don't, you still owe that duty until settlement. And then after the transaction's over, I cannot use the knowledge that I learned about that client during the transaction to try to benefit me. I can't use that knowledge against them. I sometimes learn a whole lot about people, and I can't use that against them for my benefit after our agency agreement is over. And another possible exception is the duty of confidentiality. My former clients have to be able to trust that when our agency agreement is over, I'm not running down the street shouting out their confidential information. I know why they want to sell, right? They have to trust that I'm maintaining that level of confidentiality, except let's imagine a scenario. You have a listing agreement. The property never sells. The listing agreement expires. You and your seller part ways. Later, the seller hires a new firm to sell their property, and you now bring the buyer client to the transaction. Who do you owe that confidentiality to today? You owe that to your buyer. Today, the buyer is your client, the seller is your customer. So anything I learned about my seller during that transaction, I have to share with my buyer client. I tell my client everything about my customer. I tell my customer nothing about my client. That's like the only reason I would have to share personal confidential information. And we had a good discussion come up last night about this. And, you know, somebody said, well, what if this, because the seller knows me, so an offer comes in from Julie Campbell. What if the seller says, God, this person knows too much about me. I don't want to deal with this buyer. Well, as we're going to learn in Unit 10, 9, and 10, when sellers are presented with an offer, they always have three choices. They can accept it, they can reject it, or they can counter it. So if my buyer presents an offer to my former seller, does my seller have to enter into that contract? It might depend on what I know about him, right? The seller has choices, and hopefully their new agent is explaining that to them. Questions or comments on this? I need to go off book for a minute. There's something that they talk about in the syllabus. It's not in your textbooks. Remember, if we do syllabus, we know it's could be a good candidate for your exam. So we're going to go off book for just a couple slides. And when we talk about agency relationships, in practice, realtors, we have two options. We could either affiliate with a firm, which we'll talk about next, or we could choose to go out on our own. So the consumer may matter to the consumer, it might not. Do I want to hire a sole practitioner or do I want to affiliate with a firm? If you're a sole practitioner, how many people are in your practice? Just one. It's sole. You are a one-man show. We'll talk more about that in license law and commission rule. But the independent broker, the individual, could act as a sole proprietor, a sole practitioner. They have to get themselves licensed, their entity licensed. Again, we'll talk more about that. But they still have a licensed entity. They still have a business. So the agency agreement is between the independent brokers company, the independent contractors company, and the consumer, soon to be client. I'll give you a few extra seconds on this slide. It's in the PowerPoints, but again, it's not in the book. So jot down, make your notes. The other choice the consumer has is to hire the firm. And again, as we've been saying, the agency agreement is between the firm and the consumer. All the brokers affiliated with a firm are agents of the firm. We're going to talk about sub-agency in just a minute. But basically what we're saying here, let's pretend you all get your license. Yay, you pass your exam and you get licensed. And you all come work for Julie's real estate shop. You all come work for me. Welcome aboard. Good to have you. If one of you gets a listing, congratulations. If one of you gets a listing, in a sense, we all get a listing. Because whose listing is it? It's mine. I am the firm. So the one of you that gets the listing, you're the listing agent. The rest of you are sub-agents. Guilt by association. You owe duties to my sellers. You'll never have a conversation with my seller. But through the relationship, and that's pretty much what we're saying with sub-agents. And again, we'll talk more about that in just a second. So the consumer can either hire a sole proprietor, sole practitioner. It has an entity, created an entity, or they hire a firm. So we can get back in the book now. And we're going to talk about different agency relationships. Firms and individual can form different relationships. And I think it's really important that you guys understand your test is not going to be on what you choose to do, how you choose to practice. Maybe you're going to go one way, maybe you're going to go the other. Your test is not going to be on what you're going to do. Your test is going to be on what you can do. So what we're going to talk about are the different agency relationships that firms can practice. Whether or not you're going to affiliate it with or not, that's entirely up to you. So everybody good with that? This discussion tends to get, why would some, I would never do that. Bravo, you don't have to. Your test isn't going to ask you personally what you're going to do. Your test is going to ask you what you can do. Okay. So look first, there's a nice little chart for us at the top of page 153. I like these little charts. They sum it up. So talking about our agency relationships, we have several different types. And the first type of agency relationship we have is an exclusive seller agency. In firms that are an exclusive seller agency, only have seller clients. They do not work with buyer clients. They only represent sellers. They only take listings. We don't see these much here in the triad, but you get into smaller areas, smaller populations. These tend to pop up. We have an instructor at Carolina School of Real Estate. She lives down near Troy, down like south of Denton. Go 109 and keep going, keep going, keep going. Uwharrie, all that, Lake Tillery. And she says every single firm in Lake Tillery is either exclusive seller or exclusive buyer. No firm down there works with both. Isn't that interesting? So are they out there? You bet. Basically, what the firm is saying is, as long as you're a seller, I will represent you. You will be my client. But if you ever want to buy property, we're going to have to downgrade your relationship to a customer. So exclusive seller agency, the firm only has seller clients. What do you think the other side of that is? Firms that only practice buyer agency. There are firms out there that only have buyer clients. They will never have property. They'll never have their own listings. So the listings they're showing their buyer are listed by other firms or for sale by owner, FSBO, for sale by owner. And again, what the firm is saying is, as long as you're my buyer, you get full representation. If you want to sell, I'm going to have to refer you to somebody else down the street. I'm going to have to refer you to another firm that does work with sellers, that does deal with sellers. You may have firms that are single agency, which means in each transaction, they either represent the buyer or the seller. They can represent either one, but they only have one client per transaction. So if I have the property listed, the buyer's got to be my customer. If the buyer's my client, I won't show them any property that I have listed. Single agency firms work with buyers and sellers, but only one in the transaction. The firm works with the buyer or the seller, only one client. If they represent the seller, the buyer is unrepresented. If they represent the buyer, they can only show other firms' listings or for sale by owner. They will never have two clients in the same transaction. We're going to introduce you to something called dual agency in just a second. So if you have a firm with two clients in the same transaction, we'll talk about dual. Okay, subagency. Let's talk about subagency. First off, subagency is an agent of an agent. The prefix sub means under, right? Submarine, for example. Subagency, agent of an agent. There are two forms of subagency. The first form of subagency is what we just talked about. You are all affiliated with Julie's Real Estate Shop. Welcome aboard. One of you gets a listing. The one of you that gets the listing is the listing agent. The rest of you are sub-agents. You're there by default. Because whose listing is it? It's not yours. It is mine. It is the firm's. Has anybody ever been open housing and you walk in the front door and the person that you meet is not the person's name on the sign? So maybe the listing agent is Julie, and maybe you walk inside and you meet Kevin, for example. Kevin is going to be a sub-agent. I'm the listing agent. My name gets to be on the sign, but Kevin is a sub-agent. Can Kevin do my open house? Yeah, because of default. Because who does Kevin represent? The firm. Kevin represents me. Kevin is a sub-agent. He's an agent of an agent. Now, does that mean the listing agent can tell all of you what to do? Does that mean the listing agent can say, go make me copies and put my listing in MLS? No, this is not a you work for me kind of thing. Who is the seller communicating with? The seller is only ever communicating with the listing agent. What this means is all the other agents in the firm have to respect that relationship. It's by default. Why are they sub-agents? Because the seller hired the firm. So again, one of you gets a listing. In a sense, all of you get a listing because it's my listing. It's the firm's listing. Another form of sub-agency is when you're bringing a buyer customer. Maybe it's in-house, maybe it's co-brokered. If you're bringing a buyer customer, if the buyer does not want to be the client, we'll talk more about that. As a sub-agent, all firms in the Triad MLS owe all sellers one duty. When I wake up every single morning, I am a sub-agent to all sellers in the Triad MLS, and my job is to find them a ready, willing, and able buyer. And if it comes from a buyer client, I'm not a sub-agent, I'm a buyer's agent. If it comes from a buyer customer, I'm a sub-agent. My duty is actually to the seller, even if I'm with a different firm. Because what's my job when I wake up every day? My responsibility is to find all sellers in the Triad MLS a ready, willing, and able buyer. I always think of a three-legged stool. What happens if one of those legs breaks? The stool falls down, right? Ready, willing, and able. There's your three legs. It's up to the firm's policy and the agreement between the firm and the seller if we allow or refuse sub-agency. The firm's policy has to allow agents from other firms to bring their buyer customer. Does the buyer sub-agent get paid and how much? It depends on what the listing agreement says. It's all hashed out in the listing agreement, the relationship between the firm and the seller. So the firm's policy says yay or nay. And if it says yay, how much am I going to pay you for bringing the buyer? Some sellers say, look, I don't care where the buyer comes from. Represented, unrepresented, Timbuktu, I don't care. Bring me a buyer. Other sellers, some firms may say, there's something out there called vicarious liability. And vicarious liability says that that customer could sue the seller or the listing firm for their inept actions. If you're allowing sub-agency, you're allowing every agent in the Triad MLS that brings a buyer customer to basically fall under your umbrella. You're an agent of the seller. Guys, bottom line, if a broker's involved in a transaction, they have to have a role. They have to have a reason to be there. So if the buyer's your customer, you're a sub-agent, you're an agent of the listing firm. When you look at MLS, remember that buyer calls you and says, I want to 123 Main Street. You go to MLS. If the buyer is not your client, if the buyer's your client, you don't have anything to worry about. If the buyer's not your client, you can look in MLS to see if sub-agency is allowed. It tells us in MLS, buyer's agent, seller sub-agent, or both. And we'll look at it. I'll pull it up on the next break. We'll look at it when we come back. So if that MLS listing says buyer's agent only, then you as a seller sub-agent can't show that property. The seller and the listing firm have said, we only want agents that have represented buyers. Sub-agency, remember, there's two forms. One of us gets a listing, we all get a listing in-house. The other form is sub-agency. The seller is represented. The seller is represented. The buyer is a customer. The agent is bringing their buyer customer. And I know it's confusing. It takes time to wrap your brain around sub-agency. I want to give it time to marinate. I want to give you time this weekend to look it over, review your notes, look in your book, think it through, ask questions, watch the recording a few times. It's tricky. Nobody is leaving this call today as a sub-agency expert. It doesn't work that way. So let me go back. Let's back up for 1 second. Put your pencils down. You got everything written down? Everybody done writing? So put your pencils down. Let's just go back for 1 second and do this again. Back to the basics. What's a sub-agent? A sub-agent is an agent of an agent. Sub means what? Sub means under. You are under somebody. So sub-agency is an agent of an agent. And there are two forms of sub-agency. First, all agents affiliated with the firm. When one of you gets a listing, the rest of you become sub-agents by default. You're an agent of me, the firm. Please note, some firms have multiple office locations. So hear me when I say firm. If the firm has 3 locations, when an agent and an office and another office gets a listing, we're all still affiliated with the same firm, right? So you have the Winston branch, the Greensboro branch, and the High Point branch. We're all still affiliated with the same firm. Questions on this? I see you guys getting frustrated, and I just, please don't. It's too early to get frustrated. If this is your first time ever seeing it, yes, you're confused. Hang in there with me. Study this weekend. What questions do I have on this? Okay, so you work for Julie's Real Estate Shop. Welcome. If you work for Julie's Real Estate Shop, you're either the listing agent or you're not. If you're not the listing agent, you're a sub-agent. One of you is the listing agent. So Christina, if you're the listing agent, that means everybody else on this call is a sub-agent. That's exactly what we're saying here. One of you gets a listing. In a sense, we all get a listing. Can a sub-agent take the listing agent client? I'm not going to let you take a client from another agent in my firm, but if the seller calls me, and Christina, I'm sorry, I'm going to pick on you. If the seller calls me and says, I'm not satisfied with Christina, I want you to terminate my agency agreement. As the broker in charge, I'm going to say, whoa, 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 let me connect you with somebody else. Let me hook you up with another agent. Christina, I'll get you a referral fee because you did do some work. But remember, I'm the one that terminates the agency agreement. So if the seller's not happy with Christina, Christina can't fire the seller. And I'm going to try to salvage the deal, right? Because I want the firm to get the transaction. So Cassandra, to answer your question, I can decide if I'm going to take the listing from Christina and give it to you. Who decides if you're the listing or the subagent? It's the nature of the relationship. The seller's working with one agent, the listing agent. That is the decision. All the rest of you are the subagent. So you're the listing agent, but not the subagent for Julie. Don't think like that. You're going too far. Come back a little bit. So if you're not the firm, Mindy, hang on to that. We'll get into that next one next. Okay. In-house, listing, firm. The second piece of subagency, the second type of subagency, is when you bring the buyer customer to the transaction. Maybe you're in the same firm, maybe you're not. The thing we need to hear the thing we need to hear here is that the buyer is unrepresented. The buyer is the customer. You list the property. Either an agent within your firm brings the buyer customer, or an agent with another firm brings the buyer customer. That's what makes you a subagent. You found that seller. Who did you work for in that case? You found that seller, that ready, willing, and able buyer. Whether or not the firm allows subagency in this sense is up to the firm's policy and the listing agreement between the firm and the seller. So Mindy's question, if you're not the firm or the listing agent, who got the listing agent? Either another firm got the listing or the seller went for sale by owner. So if you're not the firm, who got it? Either another firm or for sale by owner. And if I bring the buyer customer to the other firm's listing, we can't have two customers in the same transaction. I have to represent somebody. Remember, we talked about facilitator brokers, transactional brokers. If you're involved in a transaction, you have somebody represented. You have to have a reason to be there. And if the buyer doesn't want to be represented, your reason there is a subagent of the seller. Your role is that of a subagent of a seller. I know subagency is tricky. Again, none of you are leaving this call today as experts in subagency. How are you going to wrap your brain around subagency? You've got to spend some time with it. You've got to go back and watch the recording. You've got to study your book. Look at your book on page 155. You got to send me emails with questions this weekend. Renee, that's a little off topic. Can we come back to that? I need to stay on subagency for a minute. Why would a firm not allow another firm to represent a buyer? That may not be up to the buyer, to the firm. That may be up to the buyer. Maybe the buyer says, I don't want representation. We're going to talk about how we have that discussion with buyers in just a minute. What is the benefit to understanding subagency in real world scenarios? Because this happens every day. I had a situation once. I was listing a home that my father-in-law owned, and I had a buyer investor show up. interested. The buyer investor buys and sells properties all day long, every day on his own anyway. He didn't want to be represented. He didn't care. He just needed access to the home. He just needed to go in and look at it and do his inspections. He was a customer. He didn't have representation. The buyers may choose they don't want to be represented for various reasons. I think the majority of buyers out there, put your investors maybe, but I think most buyers out there will be clients. Why do we need to know this for the real world? Because if you ever encounter a buyer that doesn't want to sign an agency agreement, I need to know how I work with them. He did sign a contract as a buyer. He did not sign a buyer's agency agreement. He was my customer. Again, when we come back from break, I'll show you guys. We'll actually go into MLS and I'll show you. Most sellers will say they only want to work with buyer's agents. And the reason is because of this vicarious liability. Sellers don't want to be responsible for the actions of some other agent with some other firm. Can we at least agree on the risks there? You don't know this person. You don't know what kind of training they've had. You don't know what kind of experience they have. Do you want to be responsible for them? Probably not. That's correct, Alicia. I only owe car to my clients. So if the buyer's a customer, I still owe them honesty, fairness, and disclosure material facts. But in that example, my father-in-law was my client, and that buyer investor was my customer. Okay. Everybody hold your right hand up. Right hand up. Repeat after me. Everybody. Come on, this will be fun. Come on, right hand up. Okay. Julie, I promise I will spend time with sub-agency this weekend. Great. Guys, you're not leaving this call today as a sub-agency expert. I'm telling you. How are you going to get good at it? You have to spend time with it. Don't think, oh, I'm not going to worry about sub-agency until my test. I got a whole lot more to cover between now and then. Sub-agency is our first big hiccup. Truth be told, we're getting ready to hit another hiccup in the next slide. This is why it's so important you guys try to look ahead before class. Again, if this is the very first time, if this is the second time, if this is the third time you're seeing sub-agency, you got to keep going back to it. Yeah, Diego? Or were you just holding your hand up for me? You were doing a virtual hand? Okay. Agency relationships. Another agency relationship that we have, and guys, I'm going to ask, let me have the discussion. I very well may answer your question. So hold all questions until the end. I will definitely allow time for Q&A after we talk about it. Okay. So just listen. Another type of agency relationship we have is called dual agency. Dual agency is an in-house transaction. In-house means there are how many firms? You can show me on your hand. How many firms? Just one. Just one. One firm represents the seller, and that same firm represents the buyer. Dual agency is intentionally created with informed written consent. Write that down. Write it again after class. Write it again tomorrow. Write it again on Sunday. Dual agency is intentionally created. Does that mean dual agency happens by accident? No, it is intentionally created. How? We have informed written consent by both parties. The seller has agreed to dual agency. The buyer has agreed to dual agency. I can't just say, we're going to do dual, sign here. Informed written consent. We explain dual. So let's back up a minute and talk about where we are so far. And again, please hold all questions. I very well may answer them. The firm brings a seller client. The same firm brings the buyer client. Remember the law of agency? Remember old car. As I'm sure you guys are already imagining, it's awfully hard to give the same loyalty to two clients. Can we agree with that? How do you treat both fairly and equally? In a sense, we're serving two masters. We're serving two kings, if you will. We owe both duties of loyalty, obedience, confidentiality, OCAR, to two clients. Dual agency does not benefit the seller or the buyer. That's why we have to get informed written consent. Why? Because in dual agency, my role, the firm's role changes. In dual agency, my advocacy goes away. In dual agency, I cannot give advice to one client that won't harm the other. And so how do I handle that? I stop offering advice. I'm still in the transaction. I'm still getting both parties to closing, but I can't offer advice to the seller that could harm the buyer. I can't offer advice to the buyer that could harm the seller. Where are my, let's see, we're coming up on Super Bowl. Where are my football fans? Where are my football fans? Some of you, if you're not a fan, you at least aware of what I'm talking about. If you're watching a football game and you're looking at the field, you can tell quite clearly that there are two players on the field, right? You have the home team and the away team. In real estate, you have two players on the field. You have the seller and the buyer. Okay, so you got two teams. Prior to dual agency, prior to entering into the same transaction, the firm is acting like the coach. The firm is standing on the sidelines, shouting plays. This is what I think you should do. The seller has a coach and the buyer has a coach. What happens to in dual agency is that my role changes. In dual agency, the firm stops being the coach and they start being the referee. Is the referee still involved in the game? Is the referee still a very important part of the game? Is the referee telling Cam what play to make next? Is the referee telling Cam he should kick a field goal? Probably not. You guys see what I'm saying? The seller's still the seller, the buyer's still the buyer. It's my role that changes. I go from being the coach to the referee. I can no longer offer advice. I can no longer tell the players on the field what play they should make next. Dual agency does not benefit the client. And again, I'll handle all questions in just a minute. The simplest way that I know how to explain dual agency. There's one firm, one property, and two clients. Your seller is selling 123 Main Street. Your buyer is buying 123 Main Street. The firm represents both. Maybe it's one agent involved in the transaction. Maybe it's two. You could have two agents with the same firm, one working with the seller, one working with the buyer. So let's work through some scenarios. You are the firm that's listing a property for sale. You have a seller client. Everybody with me? Seller hires you to list and sell their property. When you are doing the listing paperwork with the seller, you have this conversation with the seller about dual agency. Why? Because dual agency doesn't happen by accident. Dual agency is intentionally created with informed written consent. So you discuss with the seller, this is what dual agency means, this is what it looks like, will you allow it? If the seller says, yeah, I'm good with that, any buyer from anywhere, inside or outside of the firm, can come view the property. What if the seller says no? No advocacy? Well, that's the whole reason why I'm hiring you. Why am I paying you if you can't advocate for me? So the seller says no to dual agency. That's fine, that's their choice. But what they need to understand is if they say no to dual, what they're saying is that no agent within the firm can bring their buyer client. The seller is saying no to every buyer represented by that firm. Can the firm bring their buyer customer? Yes. Can a buyer client from another firm come? Yes. Flip that coin. You're working with a buyer. You have a buyer's agency agreement. Buyer says, ooh, your firm just listed a property on 123 Main Street. Can we go see it? Well, let's talk about dual agency. Buyer says, gosh, I don't like that. I want to be represented. I want to be an advocate. If you don't agree to dual, I can't show you my listing. If you don't agree to dual, I can't show you anything that my firm has listed. Dual agency is intentionally created with informed written consent. The parties have to know that I go from being the coach to the referee. The parties have to know that my role changes. And guys, size of the firm does not matter. Dual agency is a phone call away. If I'm a one-man show and I have a listing and I have a for sale sign in the front yard, why do I have a for sale sign in the front yard with my name and phone number on it? So I want somebody to call me and ask me about my listing, right? So a one-man show can bring the buyer client to their listing just as much as some of these firms that have 300-400 agents in them. You're more likely to run into dual the more agents you have, because the more agents you have, the more listings you have. The more listings you have, the bigger chance you have of bringing a buyer. But please don't think, oh, if you're a one-man show, dual can't happen. It is one phone call away. One firm, one property, two clients, seller client and buyer client. In dual agency, the firm represents both the seller and the buyer with equal loyalty in the same transaction. And how do I do that? I take a few steps back. I change my role. I cannot offer advice. Think about it. If I represent both parties and my buyer says, I like your listing. How much should I offer? If I say, oh, just offer under asking price, I've harmed my seller, haven't I? If I say, oh, offer asking price, I've harmed my buyer. I have yet to come up with advice that I can offer either party that doesn't harm the other. And that's why my role changes. That's why my advocacy goes away. Again, buyer and seller need to understand what we're getting ready to get into. And that's why we have informed written consent. And I have to act, I own both old car, and I have to act in a way that doesn't compromise either principle. Could be one agent in the firm working with both buyer and seller. Could be two different agents in the firm. The key is that they're represented by who? The firm. Are you in a possibility of dual agency? If you're working with a buyer, are you in a possibility of dual agency? You need to look and see who listed the property. Did your firm list it? We need to have this discussion with our buyer and make sure they're good with it before you even show them the property. Because if the seller has said no to dual, then they're saying, no, don't bring your buyer in my house. Don't even show them the property. Maybe you can change. We'll talk about that in just a minute. Hang on. And I am getting ready to take a break in just a second too. For those of you getting, I hear, yes, old car to both, clients to both. Please listen. And if you're typing, you're not listening. Please listen. I will address all questions at the end. And now I forgot what I was going to say. With, again, undisclosed dual agency, we mentioned this earlier, conflict of interest. Undisclosed dual agency is not allowed. Why? Because to create dual agency, it has to be disclosed. We have to have informed written consent. I know what you guys are saying, and I hear you. You thought the whole reason you're becoming a real estate agent is so you can help people. The majority of you tell me that in your intros. I love it. I like houses and I like to help people. That's great. You're off to a good start. And now I'm standing here babbling on, talking about opportunities where you may not be able to help people. You may be in a situation where you can't help people the way you think. You want to be their advocate. You want to be their coach in the corner going, rah, 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 you got this. And now I'm sitting here saying, not in this case. I have a possible solution for dual agency. So before you get too excited, I do have a possible solution. Let's take a break. Everybody take some big deep breaths. Come back. And when we come back, we're going to talk a little bit more about dual. We're going to talk about my possible solution to dual. And then I will address every single one of your questions that I haven't already covered. Fair enough? Fair enough. Y'all go take a break. We need a break. Okay. All right, are we back? I'm pulling up this thing in MLS to show you guys real quick so we can, I know I promised I would do that for sub-agency. So we'll look at that. And then we'll go back, finish our dual agency discussion. I've seen your questions in the chat. I think I've answered most of them, but when I'm done, I will address all questions. I promise. I promise. You guys are going to spend time with dual agency as well. Yes? That wasn't really a question. That was a statement. That was a matter of fact. You will spend time with dual agency. So let me take attendance. And I went ahead, I logged into my MLS. I saved you the trouble of viewing that. But we're going to look at, if I were to input a new listing in MLS, you get like this form, and don't focus on this, but I just want to show you guys when you're inputting stuff in MLS, and we'll talk more about this in Unit 8. You guys see right here where it says agency type? That yellow means it's a required field. First off, I can't activate the listing without that information. But when I do my little drop-down boxes, what are my choices? What's the agency type that I will allow for this listing? I'll either allow both, I will allow a buyer agent only, or I will allow a sub-agent only. I've never seen sub-agent only. That makes no sense. So what are you going to see? You're going to see either a buyer agent only or both. So if you're working with a buyer customer and you come to MLS and it says buyer agent only, can you show your buyer customer that listing? And the answer is no, you can't, because the seller has said, I only want to work with buyers that are represented. I don't want to work with buyers that are not represented. So when your buyer customer wants to see that property, that's what you're looking for. Save yourself some time and look here first. This is information that you all don't see on like Zillow and Realtor.com and all that. There is that information that you can only see in the MLS. Okay. Again, it's up to the firm's policy if we allow sub-agency. It's an agreement between the firms. So we'll see this again in Unit 8 when we look at our agency agreement. You're welcome to look ahead this weekend. I beg you to look ahead this weekend. Okay. So now let's get back into dual agency. Since dual agency is created with informed written consent, undisclosed dual agency is never allowed, which means I just can't start acting like an agent for both buyer and seller without having the dual agency conversation with them. Please, again, write it down 6 more times. Informed written consent. We have to inform the seller. If you agree to dual, this is what's going to happen. We have to inform the buyer. If you agree to dual, this is what's going to happen. And when we look at our agency agreements next week, we're going to see where they get their written consent. Yes, I agree to dual. No, I do not agree to dual. It's right there in our agency agreements. So what we want is disclosed dual agency. Disclosed dual agency is purposely created. Again, it doesn't just happen. You just don't start acting like a dual agent. It happens with informed written consent. Understand, even under dual agency, that does not give me a golden ticket to run out and start sharing everybody's confidential information. I still owe my clients confidentiality. The only thing that changes is my role, my advocacy. So I can't, I can't tell my buyer, I know the seller will accept less than asking price. That's still confidential information that I keep on behalf of my seller. Usually when we talk about confidential information about the other party, I always think of price. What are they willing to offer? How low are they willing to go? Various terms of the offer, and motivation. Why are they selling? Why are they buying? Price, term, and motive. Dual agency. The simplest way I know to break it down. One firm, one property, two clients. That says client. To answer somebody's question before break, what do I owe my client? I owe my client old car. So now in dual agency, I'm having a situation where I owe two people old car. And how do I do that? I take a few steps back. I change my role from coach to referee. Okay, I'm going to go back and address some questions. Let's open it up for questions, and then we'll talk about the possible solution to dual agency. So let's see. The firm is the agent, represents both, but you would have two of your agents or just one. Dual agency, it can be one agent, it can be two. It is one firm. So you could have one agent in the Greensboro branch that listed the property. You could have another agent in the High Point branch that brought the buyer, right? Office location doesn't matter. You could have multiple offices within the same firm. When you join your firm, they will let you know if they have other locations. So in dual agency, we just make sure nothing illegal happens and oversee it pretty much. I'm guiding them through the transaction. I'm getting them to closing, but I'm doing it without advocacy. In dual, if you tell your buyer to make your best offer, yeah, I mean, that's about all I can tell my buyer in dual agency. When my buyer in dual agency looks at me and says, how much should I offer? That's about the only thing I can say. Bring me your best. I can't guide them towards what I think my seller wants. And when my seller looks at me and says, should I accept this offer? I can't guide them towards accepting my offer. Does a dual agency agreement provide protection against negligent omission compliance? No. And Natasha, thank you. That's another good point I want to bring. In dual agency, do I still owe both parties disclosure of material facts? What have we said about material facts? I never have a reason not to disclose material facts. And that applies in dual agency. So in dual agency, yes, I still disclose material facts. Please hear me. I never have a reason not to disclose material facts. So now that we know a little bit more, if you're my client, I owe you disclosure material facts. If you're my customer, I owe you disclosure material facts. Let's take that a step further. The listing agent owes disclosure material facts. The buyer's agent owes disclosure material facts. The sub agent owes disclosure material facts. The dual agent owes disclosure material facts. I never have a reason not to disclose material facts. If I ever acted in a dual agent situation, what was the hardest part? I've not worked both sides of the transaction, but myself and one of my colleagues have worked. And, you know, we worked together for the best interest. We didn't stand around and chit chat about our clients, right? Like I didn't go to him with the water cooler and be like, let me tell you something about my buyer, right? He and I used to go to lunch a lot too. I don't even think we went to lunch during that time. So we just tried to kind of, you know, maintain, but we didn't run around discussing. Me personally, everybody please hear me when I say this. Remember what we said, your test isn't on what you can do or what you're going to do. Your test is on what you can do. I made the personal decision when I went into sales that I will not be a dual agent in a transaction. If I'm in a dual agent transaction, I'm with somebody else in the firm. And that was simply a personal decision that I made because, as you guys can imagine, I really didn't want to put myself in that situation. So if I'm a dual agent, I'm in dual agency with somebody else in the firm. Back to our airplane. Somebody asked, remember our airplane? Your clients go in first class, your customer goes in coach. Guess what? In dual agency, everybody's flying first class. Nobody's in coach. I don't have a customer to put in coach. I have two clients. So they're both in first class together, both expecting champagne, both expecting a warm towel, both expecting the benefits that you get flying first class. Great question. How do you give advice? I don't. And that's the key to dual agency. My advocacy goes away. So yeah, Dawn, me personally, again, you guys, your test is not going to ask you. You may be sitting there right now trying to decide what you're going to do. Your test is not going to ask you what you're going to do. Your test is going to ask you what you can do. So do your head one way or the other. Can you be a dual agent? Can you work with both parties in the same transaction? Do your head one way or the other. Yes or no? Can you? Yes. Are you going to? That's something for you to figure out once you get your license. That's entirely up to you. People that have, again, dual agency does not benefit the clients. Dual agency does not benefit the buyer or the seller. And part of that is they need to know going into it what they're losing. And what are they losing? They're losing confidentiality.
I have a question.
Yeah.
So let's say that we're working for a firm and we're representing the seller, or we have a seller client. And then let's say that we know somebody personally that wants to buy the property and they ask us to represent them as well. Will this be one of the situations where the dual agency would be an option if they both parties signed on to it?
He's got it. If both parties agree, if I have informed written consent of both parties, one firm is representing two clients in the same property, the same transaction. Yep. As long as I have informed written consent of both seller and buyer. So somebody used to work as admin for a firm. I feel you. I'm with you. I too used to answer the phones. Again, why do I put my name and phone number on the for sale sign? I want my phone to ring, don't I? I want people to call and ask me about my listing. And experience has taught us the majority of the people that call off of a sign don't have agent representation. If they had agent representation, they'd have their buyer call, or I'm sorry, their agent call, right? So trying to get the phone rings, and that's why I say dual agency is only one phone call away. All you need is one buyer to call and say, ooh, I like your listing. Can you represent me and I'll buy your listing? I mean, there's more involved in that, but the big picture is, now if the buyer's represented, they're probably going to have their agent call. If the buyer's calling off the sign, most of the time, not all the time, but most of the time, they don't have representation. So buyers have choices. Do I have to work with the buyer as a client in this scenario? Could the buyer work as my customer? And if the buyer's my customer, am I in dual agency? No. Because dual agency is how many clients? So if the seller's my client and the buyer's my customer, I'm not in dual. I owe the seller old car. I owe the buyer honesty, fairness, and the disclosure of material facts. 2 clients. The seller is represented by the firm. The buyer is represented by the same firm. The seller is selling 123 Main Street. The buyer is buying 123 Main Street. We good so far? Okay, again, I'm going to talk about something. Please hold your questions until the end. I think you guys are typing and you're not listening. And in the meantime, I'm answering your questions. So that's why I beg you to please hold your questions until the end. I will leave plenty of time and I'm around all weekend. So what's the possible solution to dual agency? Rest assured, buyers and sellers, there is a possible solution, and this will make you feel better about real estate. The possible solution to dual agency is something called designated dual agency. Designated dual agency is a form of dual agency. Designated dual agency is taking dual agency one step further. In order to have designated dual agency, we have to have both parties agree first to dual. In order to do designated, we have to have both parties agree to dual. They agree to dual, we give them the option of designated. The firm can do designated dual agency as long as they have a written company policy in place about how they're going to handle it. Not all firms practice designated dual agency. We'll learn in just a minute, for example, the one-man firm, the sole proprietor, can't practice designated dual agency. Designated dual agency is always 2 agents. Never one. So you have one agent of the firm representing the seller. I can't talk and type at the same time. So you have one agent of the firm representing the seller. You have a different agent of the firm representing the buyer. So if you're a one-man show, you can't do designated. And what happens in designated? Again, we first have to have permission. We first have to have agreement to dual. Imagine, if you will, that this pink line is a wall. In dual agency, the firm and all of the agents are straddling the wall. You got the buyer on one side of the wall. You got the seller on the other side of the wall. And the firm and the agents are straddling the wall. This is dual agency. What happens in designated is that the broker in charge, BIC, broker in charge, designates one agent to work exclusively with the buyer. They designate another agent in the firm to work exclusively with the seller. One agent has been kicked off the wall to work only with the buyer. And a different agent has been kicked off the wall to only work with the seller. Where are those agents now? They're no longer straddling the wall, are they? One is working exclusively with the seller. The other is working exclusively with the buyer. The firm and all of the other agents are still straddling the wall. The firm remains in dual. One agent designated to work exclusively with the buyer, a different one to work exclusively with the seller. These 2 agents can now proceed. They might as well be with 2 different firms. They are separated by the wall. Now, can the buyer's agent offer advice? Now, can the seller's agent offer advice? What about the firm? Can the firm offer advice? No, because they remain in dual. One agent is designated to work exclusively with the buyer. A different agent is designated to work exclusively with the seller. Is this making you all feel a little bit better now? We're getting the warm fuzzies about real estate back. You guys tend to get mad about dual agency. And I hear you. I hear you. So now when the seller asks their agent, should I accept this offer? Their agent's going to give them advice. When the buyer asks their agent, how much should I offer? They're going to give their buyer advice. These two agents' roles change again. They went from being the coach to the referee, back to the coach. These two agents are once again standing on the sidelines going, get a home inspection, accept that offer. Some caveats, of course, to designated dual agency. Again, well, first let me say, a one-man show can't be designated dual because I need two agents. But if it's a small firm, like 3 agents, they may choose not to practice designated because they're close and they work together every day, right? The caveats to designated. The agent that's designated can't be designated if they have confidential information about the other party. So prior to being designated, the broker in charge is going to look at the listing agent and say, do you know anything about my buyer client that can harm them in this transaction? The buyer's agent says, I don't know, seller. I don't know anything about him. The firm says, great, I'm going to kick you off the wall. So this is the firm. This is the buyer with their agent. This is the seller with their agent. So the firm looks at the buyer's agent and says, do you know anything about my seller that can harm them in this transaction? The buyer's agent says no. The firm says, great, I'm going to kick you off the wall and I'm going to designate you to work exclusively with my buyer. Then the firm goes to the seller's agent. Guys, I'm going to answer your questions in just a second. Then the firm goes to the agent that's been working with the sellers. And they say, do you know anything about my buyer that could harm them in this transaction? And the seller's agent says, yeah, I mean, our kids play soccer together and we're on PTA, da, 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 da. Could the broker in charge be concerned that there's information that the seller's agent has that could have hurt their buyer, that could harm their buyer? Understand, the firm still has a duty to protect their buyer and their seller. So you can't be designated if you have confidential information about the other party going into designation. So what happens to the listing agent? We assign somebody else to that seller. I'll get your referral fee. You cannot be designated if you've received prior confidential information about the other side. The other caveat to designated agency is the provisional broker, PB, is the provisional broker. That's you guys once you get your license. We'll talk about PBs. The PB and the broker in charge cannot be designated opposite of each other. As a provisional broker, when you affiliate with a firm, your broker in charge is pretty much going to be in your back pocket. They're going to be overseeing your first couple of transactions. Guys, they're not going to hand you a license and let you run amok on the street. They're going to guide you. They're going to be with you. They're going to be with you at your listing appointment. They're going to let the top producer go with you to your first closing, right? They're going to make sure that you get off to a good start. And the very nature of the business, of the relationship between the provisional broker and the broker in charge, the broker in charge, if they're doing their job, they know something about the provisional broker's client. They might have been there at the listing appointment. So if the BIC is doing their job, they know something confidential. So just by the very nature of their relationship, this is not allowed. Any other combination is okay. A PB can be designated opposite of a PB, provisional broker. A PB can be designated opposite of a broker. You can have a broker and a broker. BRO. You can have a broker and a broker in charge. Any other relationship is allowed as long as the agent has not received confidential information about the other party. PB and BIC are never allowed to be designated opposite of each other. Any other combination is allowed as long as the agent has not received prior confidential information about the other party. And thank you for answering. The PT is problem topic. And as I was going to say, this problem topic is hands down the #1 problem topic in Unit 7. The provisional broker and the broker in charge cannot be designated. Please hear what I'm about to say next. The BIC and the PB can be in dual. They can be in dual. They cannot be designated. All right, what other questions do we have about designated? Designated is a form of dual agency. I can't have designated if I don't first have dual. You get agreement to dual, and then you make the offer to take dual a step further. Question came in, dual can have 2 agents, correct? Dual can be 1 agent, dual can be 2. Designated is always how many? Designated is always 2. Dual can be 1, dual can be 2. Designated is always 2. Correct. A provisional broker and a broker in charge can be dual. They cannot be designated. So remember when we just said you can't be designated, you can't be kicked off the wall if you've received confidential information about the other party. Everybody good with that? If you've received prior confidential information, you can't be designated. You can't be dual because you're going to harm the firm's other client. So you were asked if you know, and you said no, and both of you were kicked off the wall. Great. Now we have 2 agents that are designated. What if after designation, the buyer's agent learns something about the seller? Does the buyer's agent have to disclose that to their buyer client? Yeah, because they've been designated to work exclusively with the buyer. So this received confidential information only applies to prior to being designated. Once you're designated, if you learn something about the seller, you owe it to your buyer to call them and tell them that. Dual agency contract have to be complete before a buyer can submit an offer. Yes. They were very kind and they put the dual agency consent, the designated dual agency consent is in our listing agreements. So when we look at our listing in our buyer's agency agreement. So when we look at our agency agreements next week, we'll see dual agency again. We'll see designated dual agency again. It's not a separate contract. Thank you, Forms Committee. They lumped it all together So the listing agency covers dual, the buy and designated, the buyer's agency covers dual and designated. So we'll see that next week. So let's go over page 163, kind of help sum this up, clarify. Are we spending time with dual and designated? Are we spending time with sub-agency? If this is your first time seeing it, if you didn't get a chance to look ahead at Unit 7 before this week, I'm sure you are feeling lost. And the best advice I have, even if you looked ahead, I'm sure you are. Please don't throw your hands up in the air and say, I can't do this. I'm telling you. Do you think I got dual agency the first time it was explained to me? Heck no. I had to expose myself to it over and over and over again. Let's see. This doesn't cover if an agent is helping you buy and sell. That's correct. That's 2 transactions. So if you have an agent listing your home, that's 1 transaction. They're going to help you buy a home. That's totally different transaction. Good question. Dual agency is somewhat avoidable. Ding, 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 ding. Dual agency is 1 phone call away. All I need is 1 person to call me off my sign or call me off of my Zillow and say, I'm interested in 123 Main Street. Can you help me? You bet. Have somebody come into your open house. Buyers unrepresented. They want to buy your open house. You know you represent the seller, right? You're there doing the open house. Buyer says, ooh, can I write up an offer? You bet. Guys, dual agency happens easily every single day. All you need is 1 buyer to be interested in one of your firm's listings. Okay. So let's sum this up. On the bottom, page 163, when we get into designated, dual agency does not go away. Designated is a form of dual. So upon designation, remember, 1 agent is designated to work exclusively with the seller. A different agent is designated to work exclusively with the buyer. The firm and all the other agents are still straddling the wall. They are still in dual. Dual agency is only for in-house transaction. 1 firm. If ABC has the listing, if firm ABC has the listing and firm XYZ brings the buyer, that's a co-broker transaction. You have 2 firms bringing their people. In-house means both are under the same firm. Dual and designated, we need written approval. How do we get that? That's what our agency agreements help us do. Dual and designated is both covered in our agency agreements. As a matter of fact, when you're looking ahead at Unit 8 for next week, look in the listing agreement, look in the buyer's agency agreement. You're going to find dual agency explained to the buyer. You're going to find dual agency explained to the seller. And as we've been saying, we'll talk more about this next week too, but we got to get everything in writing. Because if you have verbal, you got nothing, right? What if the seller looks at you and says, oh yeah, that's fine, I'm good with dual. If you don't have that in writing, that meant absolutely nothing. So everything's got to be in writing. Question came in, do the designated agents have to be assigned before the buyer can submit an offer? Yes. Because it's all in writing before we make the first offer. So again, we'll see that next week. Let's see. So, okay. Designated dual agency is an adverse selection. I hear you. If the BIC designates a provisional broker against the broker in charge, that can't happen. Let me go back for a second. That cannot happen in designated. But to your point, if the BIC, well, I just lost my chat. If the BIC, that's really weird. Y'all, I just lost my chat. My monitor just went out. So don't chat me, it's gone. Hang on. Just 1 second. Did I get my chat back? Nope, it's gone. I don't have it. Can I figure this out? Okay, I don't have time. So if the question came in, if I can remember, about the level of experience, the provisional broker doesn't have as much experience as a broker, another broker in the office. Remember, the firm remains in dual. So the broker in charge should be straddling the wall. Not all BICs practice. Okay, not all BICs are in sales. So I may just have to do that. Not all BICs are in sales. So a lot of your bigger firms, the broker in charges are not going to practice, right? So you're not going to encounter that. Why? Because if they're doing their job, they're working with all the brokers, right? So the broker in charge may just have an office policy in general that says, I'm not going to be designated because I know too much. But could there be a disadvantage because somebody knows more than another? Of course they can, but remember, the firm remains in dual. So they should be able to rely on anybody in the firm, anybody with experience, anybody to help them out. Okay. And I'm done over here. So I'm just going to have to come back and check my chat periodically because it got lost in my third monitor. My third monitor just went out. Maybe I can get it. Okay. Okay, dual agency is not eliminated. Dual agency, the firm still straddles the wall, only in-house transaction, written approval from both parties. We'll see that next week. The individual designated dual agents will act only as an agent for a principal for whom designated. Again, once you've been kicked off the wall, once you've been designated, both agents proceed. We might as well be with two different firms. One agent is designated to work exclusively with the seller. A different agent is designated to work exclusively with the buyer. And one of the keys, one of the tricks to a firm practicing designated dual agency is they have to have a company policy in place. They have to have a firm policy about how they're going to designate, how they're going to handle it. Not all firms practice designated dual agency. So in order to practice, and again, a great example of a firm that may not practice designated could be the firm that only has, a handful of agents. Maybe their thinking is they work so closely together anyway, they know what's going on with each other's transactions. What if you had a husband-wife team and they were the firm? They probably wouldn't be able to practice designated. A broker cannot be appointed as a designated dual agent for one party if they have received confidential information about the other. You can't be designated if you've received prior confidential information about the other party. Your BIC will ask you, do you know something about the other side that could harm my client in this transaction? And again, with designated dual agency, the BIC and the PB cannot be designated opposite of each other. Stop sharing and see if I have any questions. What questions on dual do we have? Designated. It's tricky, doesn't it? This is why we have stuff like pre-licensing and post-licensing and continuing education. Because once you guys get your license, it becomes your responsibility to explain this to your buyers and sellers. We cannot just hand them the agency agreement and say, this is what we're going to do, sign here. Remember, as licensees, we help educate the public. And when it comes to dual and designated, make sure they understanding this transaction before they get in. Keep it in mind, they don't have to agree to it. If they say no, then we need to make sure that they understand their consequences. If the seller says no, that's fine, seller. I work in a firm with 500 agents. If you say no, what you're saying is no buyer client from my firm can view your property. That's huge. Think about that. I don't know, Matt. Okay. Are we listening? This is important stuff. You think you're going to see lots and lots of test questions on this? Yeah. So I hope you guys will review it, spend time with it. One more thing on agency relationships. Everybody take a big deep breath. Let's all breathe together. Ready? Doesn't that feel nice? Anybody else do yoga? I've recently gotten into yoga, and you know what I've learned? Dang it, I've learned how to breathe. So breathing is important. One last point on agency relationships is talking about agency rentals. If you're dealing in rentals, you're a property management relationship. So the owner hires a property manager to manage their rental properties. So in this case, the landlord is the client, the tenants are customers. In a residential rental relationship, it's rare for the tenant to be represented. So because of that, dual agency and property management is really, really rare. Usually when tenants are represented is when a commercial transaction. So let's look at some stuff. Then we're going to talk about what next week looks for us. Pages, make sure I get everything. We'll do agency 156. We're going to do that. Examples, pages 162 and 163. When we get into 8 next week, we're going to talk about oral versus written. So we'll revisit dual agency again. But you can kind of look ahead, start looking at these situations and answers 162 and 163. There's also let's go back to page, let's see, our comments, our law and rule comments. Remember they start on, let's go back to the back of your book and look at page 716. Remember the law and rule comments that we talked about earlier today? 716 gets into agency agreements and disclosures. We will start next week talking about agency disclosure. You can read more about dual agency, page 718. There's designated agency on page 719. Again, you're reading the comments anyway. Just pointing out a lot of stuff we're going to talk about. We've already talked about a good chunk of it before we ever got. So this is yet another way to help you guys expose yourself, get this information. Let me also show you in Learn, Test, Pass, I do want to point this out. Again, next week, we're going to get into our agency agreements. And when you look at Unit 8 in your textbook, you have agency agreements in your textbook. But the agency agreements in your textbook are old. They're out of date. So when you guys are looking at agency agreements, I want you to come to Learn, Test, Pass. All forms that we need to look at, never look at a form in your book. It drives me nuts that they publish forms, because as soon as they do, the forms change. So anytime we're looking at a form, so in the Unit 8 material of Learn, Test, Pass, you have the exclusive right to sell listing agreement. Again, we'll talk about this next week. But if we scroll down, here is dual agency as explained to the seller. I think it's good for you guys to look this over. The listing agreement explains dual agency to the seller. You're going to find something similar in the buyer's agency agreement, also in Learn, Test, Pass. And you can see the seller has choices. They either authorize the firm to act as a dual agent, or they desire exclusive representation and do not authorize the firm. The seller has to give authorization. Same thing with the buyer. The buyer has to give authorization. And if the seller agrees to dual, do we want to take this a step further and authorize the firm to designated? Back in my admin days, I did a lot of new agent training. So I got you guys as soon as you got your license, when you started with a firm. And hands down, the number one question I got was, how do I know what to say? How do I know when I'm explaining dual agency to a seller, how do I know what to say? And guys, I'm a big fan that if you're familiar with the forms, let the forms help you put the words in your mouth. Why recreate the wheel? It's right here. So if you're familiar with the forms, it helps you better know what to say. It helps you better know how to explain it. Don't sit down and read it to them. Nobody likes to be read to. I mean, I like to be read to. Nothing puts me to sleep faster than when you read to me. That's nighty-night time, right? So put it in your own words, but use the forms to help you explain this to the seller. Use the forms to help you explain this to the buyer. So next week, we're going to finish Unit 7. I'm close. We're going to get into Unit 8. Unit 8 is discussing more of our agency agreements. I think it hurts you guys one bit to look ahead. You got the exclusive right to sell, and you got the exclusive buyer agency agreement. Both talk about dual agency. Questions? Comments? You guys got awfully quiet on me. It's a lot to take in. Today's a big day. Today's a big day. I tried my hardest to warn you that this was coming. Brain cells are fried. I hear you. Go get lunch. I don't know about your house, but my house Thursday night is wine night. So I get to do this again tonight with my night class. So like at 8:32, I'll be pouring my my Thursday night wine. Trust me. Drink a glass of wine tonight. It can't hurt. Tonight, not now. Tonight. It can't hurt. What was the last one? It was the listing agreement, and it was the buyer's agency agreement. They're both in the Unit 8 Learn, Test, Pass materials. Oh, Drew, that's not fun. Yeah, Tara can drink sparkling grape juice with us. Sorry, Tara. We will Kahoot. I got to cover material before I can Kahoot. But remember, you guys got a quiz at the end of Unit 7. Again, we haven't done agency disclosure yet. We will get to that next week. Oh my God. One of you can't even buy wine. All right, on that note, because now I feel old. So on that note, I'm going to go get lunch and dream about my wine. You guys have a good weekend. I really don't want to start anything new today. And I figure our brains are done. So promise me you're going to spend time with this stuff this weekend. Promise me you're going to reach out to me with questions. Promise me. If you don't, your exam is going to hurt. I don't know another way to put that. How do you get ready for your exam? Practice, practice, practice. Expose yourself to it. Wrap your brains around it. Okay? That's all I got.